It was not that warm a day. And I mean, I think a normal dog probably would have been just fine, even without water. But, you know, based on this dog's medical condition, that was problematic. But there's no evidence that she was told or that she knew or that she understood that she couldn't leave this dog in the car.
Why did she lie to the police about coming back and bringing Nigel water?
Well, I mean, I think that's sort of irrelevant to the.
Is it now?
I think it is, but and I also think.
Well, remember, we're looking at the evidence in light most favorable to the Commonwealth, not Miss Casey.
I mean, if you look at it in the light most favorable to the Commonwealth, I think you still do not get past the fact that this dog, the evidence, the testimony of the doctor was excitement could very well have triggered this this type of what happened here.
Was there any evidence that depriving the dog of drink for 5 hours was cruel?
I don't think there's any evidence of that. I mean, the doctor did testify that this could lead to a sort of slow progression where the mucus gets heavier and then the dog aspirates.
Well, that sounds like testimony that depriving the dog of drink for 5 hours was cruel. What was the name of the expert?
Doctor, she's got a hyphenated name here.
Oh, that's all right. I'll find it. I'm sorry.
Smith Blackmore.
Go ahead with your argument. I apologize.
Right.
Well, the doctor also testified that the dog would have suffered during this time.
If that took place, I mean, I think it is our contention that we're not sure, and the judge as fact finder had no way of being sure that what exactly led to the dog choking. Was it being excited? And again, Mr. Shea, there was testimony that Kevin Shea banged on the window and the dog was jumping up and down and getting all excited. I think under the doctor's testimony, this would count as excitement, as exercise, as anxiety if he was anxious about strangers. And if this happened at
the doctor testified that the anxiety and distress of the situation combined with Nigel's attempts to breathe caused him to vomit, and he aspirated that vomit.
Right. Now the question is, did that happen because did that happen at, say, 5 o'clock because he'd been in the car for a long time? Or did that happen? Again,
there's no element in the statute that the Commonwealth is required to prove what time the dog suffered.
I guess my point is that if the dog suffered this, whatever this incident as a result of jumping up and down, the question is was it cruel to leave him in the car for any period of time? Because our contention is that there was no live dog in this car, or there's a very substantial possibility based on
that can't be right. We can't be in a position where you want us to rule as a matter of law that the dog died in 45 minutes. What evidence is there of that?
There's evidence that the dog, again, the doctor said this type of excitement could
have happened. Okay, but it also could have happened that he was there for hours and hours before he died because he was in a hot car without any drink.
Okay,
we're taking the inferences in the light most favorable to the Commonwealth.
Well, I think the point is that the Commonwealth could not eliminate two equally likely possibilities. Again, based on the doctor's own testimony, she had this dog and she performed the necropsy on the dog, and she couldn't tell. There's a lot of things.
Specific? I'm looking at her testimony right now, Mr. Curham. What specific testimony of hers are you relying on for the contention that you're making now that these were equally, that the evidence showed that these were equally likely possibilities?
Her testimony that I think it's, let me see if I can pull that up.
Well, I have a question that might cut
Sure.
through some of this. What does it mean that the statute requires that the cruelty be unnecessary? In other words, if your theory is right that the dog died after 45 minutes, was it necessary for the defendant to stay away having drinks at lunch? When would cruelty be necessary?
I'm not sure if we even get to that point. It may have been cruel to leave this dog in the car for that period of time. Now, when we're talking about temperature, the windows were cracked. The photographs in the Commonwealth's appendix shows, looks like it's between 2 and 3 inches that they were open. It was an October day.
The person in the next car said that when she came back, the heat came pouring out of her car. So the trier of fact could believe her testimony that the interior of the car would be hotter than the ambient temperature.
She's talking about her car, where the windows were closed. There's a difference when the windows are open. It looks like 2 to 3 inches. And so, you know, this isn't the typical hot car case where somebody leaves a dog with closed windows in the sun and it's 90 degrees and 120 in the car.
Well, so this was tried, jury waived, correct?
That's correct.
And so there was no specific verdict or request for rulings of law, so that if we find or we rule that any theory was proven, then that's enough. Is that correct?
I mean, I think that's correct. Volume 2, pages 21 to 22.
Is what you're relying on? Okay.
Right.
Thank you.
Dr. Blackmore testified that he was exposed. She said being in a car contributed to her difficulty. He was exposed to sights and sounds that were unfamiliar, and she talked about the humidity of the vehicle, but that may not be what I'm relying on. I think there was testimony in her direct testimony that the dog was excited, and I'm sorry, that excitement and anxiety and being in a strange, unfamiliar place could have triggered this. And you know, again, the doctor could not eliminate this as a possibility. And when we know that this happened, I think the evidence is simply legally insufficient. And also, there was testimony that a dog in this condition probably shouldn't have been left in the car, but there's no testimony that she was alerted to that fact. You know, don't ever leave your dog in a car like this.
Well, she knew the dog was wearing a harness, and she said the dog was a sick dog with kidney problems.
Yes. So, I mean, I think that's, I mean, she obviously knew that there's evidence of that, but there's no evidence. Nobody ever told her, like, don't ever leave your dog in a car. Make sure the temperature is controlled. This might happen.
You think that that's required? It's a general intent crime, right? So I struggled, frankly, a little bit with trying to figure out exactly what that meant here, but I don't think it means that she had to know that what she was doing was going to harm the dog. I think what is required is simply that she take an act deliberately, which results in. Isn't that what a general intent crime is?
Well, I mean, I think that is, but I think there has to be some knowledge that it will be problematic. So if you took ordinary dog.
one of the elements of the crime is one of the crimes is failing to provide with proper drink, which she clearly intended, or at least the jury could so find.
Well, I mean, there's not much that I can add to what I've just said. I mean, again, I don't think that there
Okay,
was
well-
a live dog after 2 o'clock.
Thank you, Mr. Curran. Ms.
Thank you.
Mello.
You're muted.
Sorry, I was still muted there. May it please the court, Emily Mello on behalf of the Commonwealth. I would ask that the court find that the evidence was sufficient in this case. I think there are 4 theories that the evidence was sufficient on, or at the very least, the court could find that there was sufficient evidence as to one of those 4 theories. And those theories would be that the defendant caused Nigel to be cruelly killed, that she had charge or custody of him and inflicted unnecessary cruelty on him, that she had custody of him and she failed to provide him with proper drink, and that she had custody of him and she caused him to be carried in a vehicle in an unnecessarily cruel manner. The evidence of that.
Mean? Does it
I'm
mean
sorry?
that what she's doing isn't necessary, or she's doing something to the dog that's not necessary? In other words, is it unnecessary cruelty because she's having drinks at a restaurant and walking around Salem for Halloween festivities? Or is it unnecessary cruelty because there was what she did to the dog was more mean than it needed to be?
I think it's not quite either of those, but closer to the latter. I think this is a general intent crime. So what she did was she intended to leave the dog in the car for 5 hours without any water, with poor ventilation in an unfamiliar place when she knew that he had this respiratory condition, and she knew that he had kidney issues. She knew he was a brachycephalic breed, and she left him there for all of that time without access to water or ventilation. And that was the unnecessary cruelty. But of course, the court could find on a different theory. It could find simply that she failed to leave him proper drink. Similar to the Commonwealth v. Curry case, where horse is left without food or drink for 24 hours. The horse didn't die, but they found that that was sufficient under the statute. Here, of course, Nigel did
If she
expire.
had left drink in the car, just go with it, because I know that that the evidence is the other way. But if she had left drink in the car, would this be a different case?
I think it would be a weaker case for sure.
Because it can't be enough to just take an act which has a cruel result, right? There has to be something more.
No, I don't think so. And I think that the case law makes clear that the defendant does not have to think that she is being cruel. It is just whether she is cruel in fact. And it was cruel in fact to leave Nigel for this amount of time.
It's a crime, for example, to take an act which I have trouble with that. I mean, you have an animal, you may not be attuned to all the things that animal needs to be properly taken care of, and you feed them food that you didn't know was bad for them. It has a cruel result. The animal dies. It turns out that the animal doesn't handle that food very well. That's not a crime, is it? If you didn't know?
Well, she did know because it was in the medical records, and it said in the medical records that he had brachycephalic airway disease. She had brought him in for snoring, which is dogs who are brachycephalic will snore or make that stridor noise. Both of those things were in the medical records. She had him wearing a harness, which is recommended for dogs with this condition. So she did know. She knew that Nigel had respiratory issues, and she left him in a car for 5 hours without any drink, with the windows cracked a minuscule amount, 1 inch on one side, 1.5 inches on the other side. And she left him there for 5 hours. And the fact that when the police asked her about whether she had come back to give him water, she initially lied and said, well, I mean, she did lie. She said, yes, I came back and I gave him water that was in my purse. That's consciousness of guilt right there. She knew that what she did was not okay, and it was not okay for Nigel. She said to the police.
Does there have to be causation of harm? In
No,
other words,
absolutely not.
Let me finish the sentence.
Sure.
Let me finish the question if I could. So the statute literally says unnecessarily fail to provide proper drink, or words to that effect, right? So it's a crime each and every time someone could come along and say you need to be providing better food, better drink to your cats, or does there have to be some harm to the cats before there can be a criminal act?
There does not have to be harm. And if you look at the Commonwealth v. Curry case, like I said, you will see that that horse was not in fact harmed, but the court found that it was sufficient because they left the horse out there for 24 hours without proper food or drink. And I mean, and I think that is unnecessarily cruel. No one's going to come to your house and say, you aren't filling your water bowl like quite quickly enough. That's not what happened here. She left a dog in a car all afternoon on a 75-degree day when she knew that he was brachiocephalic, when she knew that he had a respiratory condition, and she didn't provide him with any water. That was completely unnecessary and completely cruel. And it definitely is.
And it doesn't matter on that theory. It does not matter that the dog had any injury at all, let alone died. On that theory, the act of not providing the water for that length of time under those conditions was criminal.
I think it could be. It would be a weaker case. It's definitely a much stronger case given Nigel's condition.
Okay, so take Nigel's condition, but still, you don't have to show it. Your position, the Commonwealth's position, is you don't have to show any injury resulting from that. The crime is complete once you take the act.
Well, I think that's what the statute says. There are theories under the statute that do require harm.
I understand. And the word cruel in some of the other sections might imply that there has to be some harm. I'm not sure. But
I think
with the failure to provide water, there's nothing, just failure to provide water.
Yes.
Okay.
And, oh, we lost you there for a second.
Yeah, it's okay.
Yes.
I could give you a dissertation on how the light passes through here, but you don't need it.
Counsel, what should we make of the fact that the civil infraction statute 140-174F requires, and I understand that this defendant wasn't charged under that, but that requires exposure to extreme heat or cold, but it's only a civil infraction. And here we had much more moderate temperatures, and yet it's a criminal penalty. Isn't that an anomaly?
Well, I think temperature was a factor here, especially given Nigel's condition, but certainly heat alone was not the issue. And in any event, the statute was written the way that the legislature, that's what, there are many theories, and one of them is, an unsafe environment. And this was an unsafe environment.
Are you arguing that part of what made it an unsafe environment was that the animal was left where passersby might knock on the glass and excite the animal?
I think that is definitely part of it. And Dr. Smith-Blackmore did testify that being in an unfamiliar location with, people going by and all of this would have exacerbated the condition, because when Nigel gets excited, he would begin to pant, and his small airway would become basically more constricted and that the mucus would become thicker. And, you know, he eventually aspirated on his own vomit and died. And even if I highly doubt that them knocking on the door was the cause of his death, but even if it was, it doesn't really matter because Miss Casey left her dog in the car with no water, knowing of his condition, knowing that there were many, many people around, that he could get excited. And this is a general intent crime. The fact that she left him in the car under those conditions.
Really? So, so she stops outside a store, Walmart. She's at Walmart. She's got her dog with her, and she has to run in for 20 minutes to go buy some shoes. That's a crime. She leaves the dog. It's
A
75
brachiocephalic
degrees.
dog
It's
should
in
never be
shade.
left in a car alone.
Sorry?
A brachiocephalic dog should never be left in a car alone.
Was there testimony to that effect at trial? Because I don't think.
There was testimony as to the condition of a brachiocephalic dog and how they are more delicate creatures and how they would have these issues. And
Right, but there wasn't testimony that said, don't ever leave the dog for 20 minutes in a car.
There was not testimony of that, but I think that leaving a brachiocephalic dog in the car is always a problem.
You know a lot more about dogs than I do, and none of that's in the record. Look, obviously, what is difficult about this case, perhaps with the exception of the horse case that you keep mentioning, is that it's a rather people leave dogs in cars.
Not for that long without water, without opening the windows. I mean, maybe they.
I don't think either you or I know that.
They might, but it would be a crime.
Okay. Okay.
And if there are no further questions from the court, I'll rest on my brief.
Seeing none, thank you. Thank you both. We'll take this under advisement.
Thank you.
All right, we are live and recording.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me this morning on your panel are Justices Englander and Grant. As you've both been here before, we know that each side is 15 minutes. You needn't use all of your time. We've read everything. We do not entertain rebuttal. With that, I'll call the next case, 20P901, Commonwealth versus James Lehan. Ms. Grant.
Good morning, Your Honors. May it please the court and Grant for Mr. Lehan. First, I'd just like to clarify something in case it's causing confusion. I did not include the vandalism charge in my statement of the case in my brief. I did mention it throughout the brief, including at the conclusion that I'm asking that it be overturned. But I just wanted to clarify that, yes, we are appealing both the vandalism and the stalking charge. Unfortunately, the Commonwealth did not make my error and responded as if we were appealing both. So I just want to clarify that. And then I'd like to start, if I could, with the simplest error in this case, because there's a lot of complicated issues. And that's that the jury relied on inadmissible hearsay in order to convict on both charges. So backing up for just a moment, the Commonwealth, in order to prove that Mr. Lehan was at the scene of the crime, introduced two types of GPS evidence. They introduced a couple of maps through Officer Klimarchuk, who was the investigating officer in this case, who received those from the electronic monitoring service, Elmo. And they introduced certified records of Elmo data, essentially, saying that that's where he was. But the jury didn't rely on any of that in order to convict Mr. Lehan, because all of those documents are incomprehensible. What I mean is, if the court looks at the Klimarchuk maps, the ones that are introduced through him, and those appear in pages 17 and 18 of my record appendix, they're exhibits 1 and 2. These maps have some red pins on them. They have some symbols. The red pins are not explained. One of them has one red pin. The other one has two red pins. We don't know what that means. We don't know if those indicate locations or if they indicate when the time starts and stops. There was no testimony about what that means. And crucially, Miss Lee's address is not marked on either of those maps. So the jury could not simply review these maps and determine that the GPS placed Mr. Lehan outside of her house. The
Can I slow
certified,
you down for a moment? Because this
Yes,
is
Ron.
helpful to me. These maps, you're saying these maps were not provided with the certification for business records?
That's
So
exactly right.
where'd the maps come from? There was no testimony as to where they even came from, right?
That's right, Your Honor. There was no testimony. There's approximately 100 pages of pretrial argument about all these GPS records. And we learn in that pretrial argument from the district attorney that
How do we know, sorry, how do we know from looking at the record that these maps were not part of what was certified? Because honestly, it's very hard to figure out from the briefs. I looked at the maps. These are the maps that say at the top, position history for James Lehan with time and date, with a time and date on them, right?
Yes, they have that, yeah. Mhm.
And you're saying, I can't really tell, it's very hard to look at them, but you're saying there's no, on these maps, there isn't a location for the victim's house?
Right. That's not on any of the maps, none of them. Neither the maps that are introduced through Klimarchek or the one map that's introduced as a certified record. We know they're not, I know they're hard to read, but if you compare just the symbols on, the two maps that came in through Klimarchek to the symbols on the maps contained in the certified records, you can see there are no maps in there that resemble the Klimarchek maps. So it's clear that they were not part of the certified records. They're introduced through Officer Klimarchek. And we know that he got them from Elmo in the course of his investigation because
How do we know that? We don't know that from any evidence that was adduced at trial, right?
No, I don't know that Officer Klimarchek is very clear about where he got them from, but the prosecutor tells the judge that Officer Klimarchek reached out to Elmo and, quote, through a series of email conversations, learned that Mr.
Prosecutor tells
Lehan.
the judge that during the motion in limine hearing before trial.
She does, yes. And there's no testimony by Officer Klimarchek other than that he reaches out to get information about where the GPS might put Mr. Lehan, and he gets these in response. That's what he says to the jury. So we don't have any authentication about the source of these maps at all. So that's
well,
a separate issue.
The judge found they were self-authenticated, correct?
He did. That was error, Your Honor, because these maps are not self-authenticating. They are purporting to show the defendant's location. You can't tell from, even if the theory that even if they weren't testimonial and weren't conveying a statement and were just, computer generated, you can't tell by looking at them what the Commonwealth says they portray. So they are not self-authenticating that Mr. Lehan was outside this address at any point. So, Your Honor, I will point out that pretrial argument, yes, it's not before the jury, but it does illuminate what we know about what the source of
I'm
these
just
maps.
trying to understand what was in evidence versus what was not in evidence, because I think that's relevant. Let me ask you this. Let's assume, and I'm not telling you that you're right, but let's assume you are. That just means the case goes back, right? It
Yes.
gets retried.
It does.
If we were to determine that was prejudicial error.
Right.
Okay.
Which I'm sorry, yes. And I think, Judge, that it has to be prejudicial error because the maps themselves, the jury can't decipher what they mean. So the only evidence that actually puts them at the scene of the crime is Officer Klimarchek's very detailed testimony about what they mean.
What if they could figure out the maps, counsel? I mean, everyone has a basic idea of what GPS does, and he's being tracked and it's following him, and there's a map with arrows that indicate direction that he traveled in. Why is that incomprehensible?
Well, the maps, at least one of the maps through Officer Klimarchek doesn't have the roads labeled. The map through the certified records doesn't have any roads labeled. It's just town names. And her address is not marked on any of these maps. And there's no testimony that her address corresponds to a certain set of coordinates either. So
but does her address have to be proven through the maps alone? If she testifies that her tires were slashed on a certain date and then she suspected this defendant because he was bothering her at the gym, and then police check his GPS, doesn't that show a link between her address and the maps?
It would show a link if that was properly in evidence, Your Honor. But what the officer testifies to is the hearsay statement of Elmo personnel who are interpreting the maps for him.
All right,
And
but
because
you've slid into something differently than Justice Grant was asking. It was similar to
oh,
my
I'm sorry.
own. The officer, they testify, there's testimony, correct me if I'm wrong, that where he was and where he stopped for a certain amount of time, and that coincides with the victim's residence.
There's testimony that he viewed the maps and that the maps were confirmatory evidence for him that Mr. Lehan was, and this is the very specific testimony he gives, left LA Fitness at 3:45, went directly to the area of 37 Golden Hill Road, which is her address, remained there a few minutes, left, returned at 10:51, remained there for a few minutes and left.
What page are you working from right now?
Sure, that's from the second transcript, pages
Yep.
54 through 55.
455.
Right. And Officer Klimarchek gets that information from the Elmo personnel with whom he was corresponding because he could not have gotten that very specific, detailed information just from viewing these maps. And that leads me to this other problem with the GPS evidence in general here, which is that none of it was authenticated, in that the Commonwealth has two threshold burdens.
Where is it in the transcript that the maps come in to evidence?
They come into evidence. I'm sorry, I didn't write down which page exactly they're introduced.
I see the question, fair and accurate depiction on page 53. So let's.
Right, it's got to be right. It's got to be right in there because they are introduced through Officer Klimarchek. But none of the GPS evidence is authenticated in another way, which is that when it comes to Officer Klimarchek's testimony, there's no testimony that these are, kept in the regular course of business. There's no testimony that they are in fact.
Isn't there a certification to that effect on the maps and the records?
There's a certification to that effect on the certified records that are introduced without a witness. Now, the reason there's an authentication problem with those certified records is that when the Commonwealth is introducing this evidence substantively, not just for the fact that it exists and was maintained by Elmo, but also to purport where Mr. Lehan was at any given time and day, have to authenticate it substantively as well. Even if that's a low burden, they have to meet that burden. And there's no certification in these records saying that it's accurate. And there's no one who testifies to that either. So
okay,
none
so
of the—
you only have 5 minutes left. Are there other, I'm sorry unless my colleagues have more questions, there are a lot of issues in this case. So are there other arguments you want to focus on in the remainder of your time?
Sure, Your Honor. I mean, I do address at length why these records are testimonial, but I think Your Honor is hinting to move beyond GPS. So that's what I'll do. The other, there's another major error here in that Detective Forney's testimony is extremely prejudicial and serves no valid purpose in this case. It is not just about the demeanor of the complaining witness. She comes in and testifies essentially that she's an expert in victim behavior and that essentially everything Ms. Lee did was in conformity with the norm. The reason this is such a big deal in this case, Your Honors, is because the fact pattern is a strange one. You have 3 months of an attempt at a romantic relationship, and then you have a passage of 3 years, right? Where essentially I'm arguing not much happens, except that both of these people are attending the gym at the same time. And what Officer Forney's testimony does is compounds Miss Lee's testimony that the way she behaved and what she did was totally normal for a victim in that situation.
But where trial counsel didn't object to Detective Forney's testimony, isn't it likely that trial counsel was making a strategic decision because he wanted to bring out the fact that the victim's friend, who was also a police officer, told her that this wasn't a crime, to make it look as though Detective Forney was overreacting because Detective Forney had all this victim training and that this other police officer didn't think this was a big deal?
Sure, Judge. I think there's definitely a strategic reason there. I can understand that strategic reason. There is no strategic reason for failing to object to expert testimony about the typical behavior of victims, and that her behavior was in conformity with that. Because
Well,
Detective...
She has the knowledge and training and experience to testify about some of the behavior of victims, doesn't she?
She testified, she has the... Potentially, she has. I argue that she does not have enough training and experience to be a domestic violence expert. But if this court finds that she does, she specifically testifies that this is not a domestic violence case. And then her testimony
I'm not sure that
is...
matters. I mean, I don't think I don't think the categories are that sort of strict and clear. That she's an expert in dealing with victims having to do with crimes that involve males and females, and when people object, when people tell you about that and when they don't. And, if someone had objected, then we might have some more information about her background, and we might have some more information about what the Commonwealth thought they could and couldn't do, but no one objected. So she testifies, I have this background and here's my testimony. Why isn't that okay for the, I mean, there's one sentence I think the Commonwealth even concedes was inappropriate, but.
Because Judge, she doesn't just testify that I have experience with victims and this is how she behaves. She testifies that other officers would be surprised that victims behave that way.
No objection to that. No objection.
I understand. And there is no strategic reason for failing to object to that very prejudicial testimony that's not supported by any evidence. All the cases the Commonwealth cites have to do with sexual assault cases and things like that, where there's a bunch of literature.
Right. And defense counsel should have objected to this. Would the prosecutor have been entitled to require the judge to rule that the defense attorney would be precluded from arguing in closing that the victim's delay in reporting the crime shows that she's not credible?
I'm sorry, I'm not sure I'm totally following.
So
but
in
if
other words, this is sort of like a first complaint, except that it's not, it's similar to first complaint evidence, except it's not a sexual assault case. The victim is going to be impeached, or there's likelihood that the defense attorney is going to argue in closing that the victim isn't credible because she delayed reporting this to anybody and she wasn't reasonably alarmed. But if that's the case, then why doesn't the prosecution get to put in the police officer's testimony that this is how victims of this kind of stalking typically react? And it's the average fact finder.
Your Honor, it is possible that in a different case where the Commonwealth met the burden of demonstrating expertise and that there was actually studies and whatever that supports that that's true, that would be an acceptable method of contesting that evidence with someone who did not interview the victim in the case. But here we don't have anything to substantiate that is a real thing about victims, and she interviewed this victim. I see my time is up. I'm happy to
actually. There's a whole nother. I apologize, but
sure.
I apologize to my colleagues. I've got to ask another question. Are you pressing the argument that there is insufficient evidence to satisfy criminal harassment as it came in?
I am, Judge. I can understand that this court may be tempted to say that, that there was criminal harassment. I would suggest that this court should really look objectively at the facts as they came in. And if you look at cases that involve criminal harassment, like McDonald or like Clemens, you have more evidence. You have, for example, in one of those, there's a bunch of innocuous conduct in Clemens. And then when the defendant is told by the police, don't approach this woman anymore, and he does and smirks at her, it's obvious from his demeanor that he had the mens rea. And in McDonald, you have a fact pattern which, viewed through the lens of the complaining witness, is pretty scary and sinister. You have this person.
Here we have, he vandalized her car. I mean, that evidence came in. You say it shouldn't have, but it's in.
Right.
That's malicious. That's mens rea. So how would we reach a conclusion that there's insufficient evidence on this record?
Because the Commonwealth has to prove beyond a reasonable doubt that is connected to that's the part of the course of conduct from the initial, romantic pursuit, which I am arguing they don't prove.
Okay.
You have testimony by the complaining witness that when she told him she was sorry, she gave him the wrong impression, he stopped. And then without additional evidence about the prior requests, it is the only fair inference is that something about her response allowed him to have the wrong impression. And we don't have anything about demeanor.
Okay, thank you.
Thank you.
Ms. Jansen.
Good morning, may it please the court, Catherine Jansen for the Commonwealth. I guess I'll just briefly touch where we left off about sufficiency of the evidence. Here, I think where you have the vandalism, it is connected to those prior instances through 2015. There was testimony.
Does every instance of the three, you have to have 3 instances of conduct, right?
Yes.
Does every instance have to be malicious?
I don't think every instance has to be malicious. I think it's the totality of the circumstances. I think, right.
Yeah, what case would you rely on for that? I'll tell you that I read all the cases I could yesterday and I did not see an answer to that question. What case would you rely on for your proposition?
Well, I guess I would rely on.
Let me put it slightly differently. I did not see a direct answer to that question.
Correct. And I think, and I would agree there probably isn't a direct answer. I think Cullen, which is 79 Mass App Court 618, and that touches a little bit of a different issue, which deals with seriously alarming. Each instance doesn't have to seriously alarm the victim separately, but I think when you're looking at the conduct, when you look at the totality of the consequences of what the defendant's doing, he's been told to stop and then they keep doing it and then he goes and vandalizes her car.
Where's
That
the
shows
evidence
malicious.
that he was told to stop in her statement to him that goes something like, none of us are going to change our conduct for you, or none of us are going to leave our boyfriends for you. That's hey, stop.
Well, that's the hey, stop. And also there was testimony that each time he asked her out, she said, no, I'm not interested. And the fact that she kept, I think also besides that hard, no, stop. And then also saying, no, I'm not interested. But then also, I think it's a fair inference in light most over to the Commonwealth, a defendant would kind of, for lack of a better way to say it, get the picture when she tries to avoid him.
The evidence was that after the as I remember it, but correct me, please. The evidence was that sometime he asked her out like 20 times in a month or 2 months, 3 years before the vandalism. And when he does, the last time is when he grabs her arm and she says, hey, and that's the last time that he asks her out. Is that right?
That is correct.
Okay.
But that is not the end of it, because after that, she said, no, it really freaked me out. And she really started to change her gym schedule.
He stares at her. He's still there every day. Right. But that's the last time that he actually approaches her, is after the event in the parking lot where he grabbed her arm. Right.
Correct. The last time he actually speaks with her, I would say going up to the window and watching her step classes is close to approaching her. And I think based on the context of their prior relationship, a fair inference that the jury could find he's staring at her.
Fine with that. Can we talk about GPS data?
Yes.
Articulate for me the best argument for why this evidence was appropriately in. And by the word evidence, let's talk about what Attorney Grant has focused on, which are these maps that were shown to Officer Klimkarchuk, and as to which he appears to testify about what they show.
Sure. So I want to start with,
first off, answer the question: is she correct that those were not certified in what was sent over from Elmo?
I would say it's not so black and white. I would say what's sent over from Elmo, that those are subsets of the certified records as
how do we know that they're subsets? If they're not in if they're not in what was sent over and certified, how do we know they're subsets?
I think when you look at this, I think if you look at the judge's reasoning during the motion in limine about this, it's clear the certified records, which include the maps and the logs, that these are just, the certified records are the fact that there's GPS coordinates that are produced from a GPS device.
Include GPS coordinates. Did the certified records also include maps?
They did, and those are reproduced at my record appendix.
Okay. Did those maps say on the top of them, position history for James Lehan?
They did, Your Honor.
Okay.
And I
But
would
those
point.
are not the same maps that were actually put in evidence through Klim Charchuk. Is that right?
I would say that I think it's a fair inference based on looking at the maps that it's more zoomed in. I think looking at the maps, and even if they look a little different, the business records themselves are the fact that there are GPS location coordinates and points, and that maps can be produced from this, and that's the business records. And they're created in the normal course of business. I think Andrade,
A map that says position record of James Lehan with a date, with a timestamp of a few hours. How is that created in the ordinary course of business?
I think it's creating the ordinary course of business because I don't think that this is the same as I'm plotting these points or these GPS coordinates are produced because they're for trial. These already exist, and the court, and they're just accessing what already exists.
The data exists, but someone needs to press a button at the request of someone to create a document that has on it position statement of James Lehan. And that was done in order to use it for trial.
I would disagree that because the maps already do exist. I think they're a zoomed in version when you look at them. And Andrade basically says, so long as an electronic record satisfies the business record exception, a printout or a subset of that is still part of the business records. And I think that's what occurred here. I think as when you have the
Andrade.
I'm sorry.
What's the site to Andrade?
Oh, sure. Obviously, it's not quite on point. It's not GPS records, but it's 484 Mass. The pin site is 410, 411.
My books in that office only go to 483.
Yeah. It is. I'm sorry. I put it in my.
It's all right. It's all right. I'll get it out of brief.
It's 403 is the end.
Isn't the way you're supposed to do this is you have a witness who can be cross-examined as to what this actually is and where it came from?
Well, in a perfect world, as the prosecutor at trial.
No. How about in a world where we have rules about how evidence comes in so that it's fair and a fair trial for both the prosecution and for the defendant?
I think
the defendant jumped up and down for hours and said, I don't have a witness. I don't have anybody who I can cross-examine to find out what this actually is. And then no one testified as to what it actually was, but it went into evidence and it went to the jury. Isn't that a problem?
I don't think it is. I think that this is GPS technology in the maps as they are not so scientifically technical that a lay juror can't understand the maps and the points on them.
How do we know that that's James Lehan's data?
Because they're certified business records.
You understand that the heading on this document is one of the most important things for the jury to see. It says position statement of the defendant, position of the defendant on those times in those hours. How do we know that's accurate? Who testified that
they're authenticated by the certification from probation that these are the GPS coordinates and maps and logs for James Lehan.
Well, two problems with that. One, your sister says that the maps that actually went into evidence were not so certified.
And I would disagree with that based on my prior argument. And the judge also found that they were a subset of those certified business records because they are already, those are come from the maps and GPS records of coordinate logs that are made by virtue of the defendant wearing.
Your position is they're properly authenticated by a statement under 79J.
I'm sorry, I didn't hear that question.
Properly authenticated and no witness is needed.
I don't think a witness is needed. We put certified business records in all the time without a witness.
Well, but if somebody says they're not authenticated,
well, I don't see how it can be an abuse. I don't see how it can be an abuse of discretion for a judge to find that these are certified records by the probation department, that these are authenticated records and put them in without a keeper of the records. That happens all the time with bank records, with medical records. So
If someone says, I need a witness to make sure that these are actually accurate, that these actually are what they purport to be, authentic.
That's what the
then
certification.
It should come in anyway.
That's what the certification's for. It's not an abuse of discretion for the judge to do that.
Well,
Otherwise, but,
79J says, and otherwise admissible, which is language that I think I have to say, this is extraordinary to me that this can happen. I mean, there's a case that is cited in your briefs called Commonwealth against Davis that goes into great depth about whether or not GPS evidence is appropriately admitted. And there was a witness there.
Correct,
Okay,
I understand.
And yet the court spent, I don't know, pages and pages discussing whether or not and how you get in GPS evidence. In that case, then, after we said it was okay, where there was a witness, the SJC took the case and it's sitting in front of the SJC now. So
Correct.
something's up.
Well, the issue with the
And yet you come
SJC,
forward and say, oh, you can take a certification without a witness, and that's good enough to show where Mr. Lehan was at that time. It's different than any evidence I ever learned in school.
well, this court, at the SJC, the issue was whether or not the GPS could testify to speed. That was the issue at the SJC.
No,
Second
it
of
wasn't
all,
the only
this
issue.
court-
I'm sorry, it wasn't
this-
the only issue. There were multiple issues, and speed was one of them. I don't know why they took it. I'm not telling you that, but I am telling you. there's a
But
lot more to
this
it.
court in Thistle 1 said that these GPS records are business records. The SJC in Thistle 2 did not overturn that distinction, didn't address that issue, and they said if they're put in with a proper certification from a probation officer, which that certification, if you look at it, it says they are made in the regular course of business, and it
Was there a
basically lays out
witness
all the
in-
things that
was
are
there a
required for
witness?
this. I'm sorry, I didn't
Was-
hear you.
Was there a witness in Thistle 1?
I believe it was just the probation officer,
Who said he was familiar with how that this person had a GPS and he was familiar with how the records are kept and created. I'll pick up Thistle 1 and take a look at it.
I'll have to relook at this one. I'm sorry. It was either a probation officer or just a regular police officer. I'm sorry, I don't remember off the top of my head, but I remember it was an issue because they weren't certified, and because it was a probation revocation hearing, they said we could avoid this all if you have a proper
that's right.
certification. And I
Because
think
probation revocation, the rules of evidence are going to be relaxed, so you're not going to need.
Of course
that.
they are, Your Honor, and I understand that difference, but we are allowed under the rules of evidence, and this happens all the time at homicide trials and other obviously very serious cases where we have certified business records that they have a certification that says they're certified, they're kept in the ordinary course of business, and they're created in the ordinary course of business, and they come in without a record keeper. That's the whole point of having that certification.
But if someone challenges their authenticity, I'm not sure that that's right. That's why they come in against the hearsay exception. That's the purpose of the statute, is to say that it's not hearsay. But if someone challenges their authenticity, that's why the language in that and are otherwise admissible is in that statute.
And
authenticity was being challenged here.
And I would point to a case cited in my brief. It's Espanol Amelia, I can't say the last part of that name, but it's 699 F3D 588 from the First Circuit from 2012. And it says the issue surrounding you do not need an expert to authenticate how the GPS maps are created. Issues surrounding the processes employed by GPS and software are not so scientifically technical that expert testimony is needed to authenticate them. And it goes on to state that commercial GPS devices are widely available, they're on our cell phones, and that a lay juror can understand that. And this is an issue for cross-examination, and which the defense attorney did cross-examine officer, basically saying, you don't know anything about these maps, you don't know how they were created, you don't know their margins vary, you don't know their accuracy. So I understand your concern, Your Honor. However, I think under the rules of evidence, this was proper.
Okay.
I'm happy to address any other questions that
What was
any
the
other issues
purpose
in this
of
case.
Detective Courtney's testimony?
Sure. Well, conceitedly, she did go too far in one instance where, the prosecutor asked, and after she talked about how victims normally react to these type of crimes and that they delay reporting. I think that was fine. I think she was implicitly qualified as an expert in victim crimes. However, I obviously wish the prosecutor hadn't asked and that the detective hadn't answered and that there had been an objection. That did it surprise you that she acted this way? However, I think at the end of the day, even if Detective Carney's testimony, even if there were some instances of improper vouching or some of it even was a little bit cumulative.
What about the question on redirect, where I think the question was, are you absolutely confident that she was telling you that the truth, or so? It was words to that effect. That's not a proper question.
It was words. I think the defendant opened. First of all, I think it opened the door to
what is overt vouching. Are you confident that she was telling you the truth? I can't remember exactly the question, but
well, right. It was
right.
Would you have? I think. Do you have any doubt that? I think the words were. Do you have any doubt that he was grabbed? And I do think it was. Probably shouldn't have been asked in that manner. I think the door was open. I think the prosecutor was probably not as delicate in asking how she should have. At the end of the day, though, it did not create a substantial risk of miscarriage of justice because clearly the jury didn't give undue weight to Detective Fiorini's testimony, especially as to that issue, which went to the assault and battery, because the jury acquitted on that. And I think at the end of the day, as Justice Grant pointed out, it's all very well, most of this was unobjected to testimony. It's all very well could have been tactical to show that, there was the other person she had talked to. Detective Fiorini's kind of like being very intense about it. And it's just kind of, it's, I think when you have a substantial risk of miscarriage of justice, you have to look at whether there was error, whether the defendant was prejudiced, the context of the entire trial, and whether failure to raise the issues below was tactical. And if you answer no to any of these, then you don't have a substantial risk. And here you don't get two of those because clearly there was no undue weight. The jury acquitted on the assault and battery. They didn't give her testimony that much weight. And there was possibly tactical reasons for not objecting. So I see my time is up.
We're going to leave it. Okay, thank you. Thank you both.
All right, looks like we are now live and recording.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me on your panel today are Justices Englander and Grant. Each side is allotted 15 minutes. Read everything. You needn't use all of your time. We don't entertain rebuttal. If we have some sort of technical glitch, we'll do our best to reestablish contact and no one will be deducted anytime. With that, I'll call our next case, 20P235, Richard Zeal versus the Commonwealth. Mr. Burkholder.
Good morning, Your Honors. I know you've read my brief. I think that the brief sets forth in sufficient detail my argument. I only want to emphasize a couple things to the court, and my observation is as follows. I think at some point when you're dealing with a diagnosis of antisocial personality disorder and a condition which admittedly 70% of individuals that are incarcerated have, the two QEs who testified in this case admitted to that at some point there has to be a limit in which that diagnosis is not sufficient for a sexually dangerous person. Certainly the courts have allowed extrapolation, and basically past conduct without change is sufficient to make that determination. However, I think there also has to be some limits, and I think this case falls outside of those limits. In Commonwealth v. George, the case that I cite in the brief with regards to both the labeling as well as antisocial personality disorder, kind of set some of the guidelines with regards to that. And the Dr. Bell, and interestingly, Dr. Bell and Dr. Ross were the same QEs who testified here, took a serious look at a couple factors. They looked at prior criminal record, they looked at institutional behavior, and they looked at treatment. So, and of course, they found that there was sexually dangerous person, sufficient to find a sexually dangerous person and to continue the commitment. Looking at the facts of my case in comparison to that case, I think I can distinguish it, and it's as follows. First of all, although Mr. Zeal maintains that his last sexual offense was in 1986, I do accept this court's prior ruling that the events that occurred in 2003 did constitute sexual misconduct, and as a result of that, certainly he has to face that. That was still 18 years ago. And
how many of those years was he in jail between 2003 and the time?
All of them. All of them. But
so what does that tell us about anything about his risk once he's released back into the community?
I think you have to look at his behavior therein. And that's where I was getting at with regards to George versus here. although Mr. Zeal has picked up 8 OBRs, the worst thing that he did with regards to sexual connotation was he used the B word in description of one of the court officer, or excuse me, the not court officers, but parolees. So in comparison, in George, there were threats of rape, there were other aggressive conduct and the like. In both cases, there was terminated participation in sex offender treatment. Mr. Zeal's certainly was previous. I found it interesting in reading the CAB report that there was a reference that back in 2007, when one of the analyses was done, there wasn't even any sex offender treatment that was recommended. And it's highlighted therein. So on top of that, this individual gets released from SORB. He then does not get criminally charged for the 2003 conduct. He does not, in fact, get any term of probation that includes sex offender treatment. And he goes into the institution. And this is a guy who's socially awkward. He's going to pick up OBRs. He's going to have trouble. There is no doubt in my mind that there are situations that are going to occur in his life. But I don't think it's necessarily antisocial personality disorder. I frankly think Dr. Cregan came up with a better diagnosis, which was inadequate personality disorder. He's certainly, based upon his vision difficulties, his limited IQ, and his history, has had difficulties throughout his whole life.
Mr. Burkholder.
Yes.
Mr. Burkholder, the jury wasn't required to credit the defendant's experts, right?
No, they weren't. And I'm not saying that they were, but I'm saying that what I think Dr. Weir and Dr. Weir and Dr. Bell relied upon wasn't enough in this case. I think after you spend that much time in the institution, if you're not displaying more of a pattern of sexual offense, I guess I asked the question in the reverse, and that's this. At what point is he not an antisocial personality disorder? Or is he like every other 70% of the people that are in there?
Counsel, I have a question. You said earlier that the 2003 home invasion on the therapist in her home met the definition of any other sexual offense under 123A1. What about the 1990 attack on the woman taxi driver? Are you also saying that met the definition?
I believe he admitted to that. So the answer to the question is yes, but I believe he also admitted to it. And the only reason that I say the 2003 is because of the fact that issue was previously before this court when the Section 12 appeal went up and it was challenged. And my sister references in her brief that, in fact, it was found to be the same. So I'm not going to challenge that.
What about the fact that the version of the Static 99 that was at issue in George was a prior version?
Well, I mean, here's the point with regards to that. Certainly it was a prior version, but I find it interesting when my sister wants to describe in defense of the closing argument that was made in the references that the new version doesn't have the same infirmities. Sure it does. It still has labels. It still has, the meaning is still unclear. It still has no base standard that were introduced or otherwise. And
well, the only thing that the SJC said was inappropriate were the labels, right?
Exactly. And I think take the labels out of this case as well, because you're still in the same situation. Where
Mr. Burkholder, in George, the SJC said that the old labels were inappropriate, but it didn't constitute reversible error because the Static 99 was explained to the jury. They offered no opinion on the new Static 99, and the Static 99 in this case was also explained to the jury.
That's correct. I don't disagree, but I think
so that leads us to conclude that that didn't create reversible error.
Well, the standard isn't reversible error in this situation is substantial risk of miscarriage of justice, which is even worse for my position. But I think this case is much weaker than George, because first of all, the governing offense in George was a rape, an aggravated rape. The governing offense in this case was a criminal offense that did not involve a sexual charge. So there's a difference. All right. Well, I mean,
meaning the 2003 home invasion? Is that what you're talking about?
Yeah, he didn't there. All right. Well, I mean, here's the problem that I have with the experts' opinion with regards to that offense, as well as frankly, the courts and the like, and the juries, and that is this. He was there for an hour. If he was going to do something sexual, don't you think he would have done it? In every other situation, he did. And he didn't do anything here. So doesn't that show any control at all? I mean, I know it sounds
He
like
had to hit him with a chair, right?
Well, yeah, he did. But the point is that he didn't commit a sexual offense.
Didn't he say
All right,
something
all right.
about how she
You're-
thought she was?
we've already said this is a sexual offense in our prior decision, so we're not going to revisit that.
Okay.
So stop telling us it wasn't a sexual offense. It was.
Okay. Well, I in my opinion, it still was 18 years ago. And in my opinion, he has done very well in the institution since then. And he, in fact, has not engaged in any sexual behavior. He's a much older man. And, you know, at some point, does his past behavior allow him to continue to be confined, or does he have to engage in treatment, which half the studies that the doctors were cross-examined with say don't help?
Well, you know, that's why we have a process that involves having a jury, which he went through, and the jury said he's still sexually dangerous, right?
Correct. That's correct.
I mean,
If there are no further questions, I think my brief sets forth my argument. It may fall on deaf ears, but that's my argument. Thank you.
ears are not
Our
deaf.
ears are not deaf, Mr.
Justice is
Burkholder. We
blind,
merely
but
asked
not
you
deaf.
questions. Yeah. Please mute your microphone now, Mr. Burkholder.
Sure.
Attorney Holmes.
Yes, good morning, Jean Holmes for the Commonwealth. There is no cause to disturb the jury's verdict in this case that Richard Zeal remains a sexually dangerous person. The court properly denied the directed verdict motions. I note that there was no argument made by counsel in either motion. However, regardless of that, the court properly denied the directed verdict motion. Looking at the evidence in the light most favorable to the Commonwealth brought forth ample evidence through the witnesses' testimony as well as the exhibits that Mr. Zeal has both a mental condition as well as the fact that he is likely to reoffend sexually. As it relates to the opinions of the experts, all of the Commonwealth's witnesses testified that Mr. Zeal has a statutorily defined personality disorder, that he also has a clinically defined antisocial personality disorder. And if you look at the testimony of the witnesses as it relates to his antisocial personality disorder, they indicated on all of the prongs, there's 3 or more that are required for an antisocial personality disorder diagnosis. And in Mr. Zeal's case, he has 6 out of the 7 that are listed in the DSM-5. And they testified that that behavior continues in the institution. He had a significant amount of disciplinary actions and problems in the institution as far as following the rules, both when he was incarcerated, serving his sentences, and as well while he has been civilly committed. In fact, he had disciplinary reports that involved anger and violence and aggression as close in time to this trial as 2018. And that anger is what was driving and has consistently driven Mr. Zeal's sex offending behavior. If you look back to the record, particularly the supplemental appendix, volume 2, there's reports from the 1980s as well as 1991, where all of the psychologists back then indicated that Mr. Zeal had a fusion of anger and violence projected and directed at women. Hostility against women is one of the risk factors that the qualified examiners testified existed with Mr. Zeal at the time of his trial. So all of the evidence supported the fact that Mr. Zeal remains a sexually dangerous person. As it relates to the static 99R scores.
When did he end his, just help me with the facts a little bit, his criminal incarceration for the event with the therapist, that ended in when, 2015?
Yes.
And then was there an SDP hearing of some sort immediately in order for him to be committed in the first place?
Yes, Your Honor. He was petitioned against before the end of his sentence for the 2003 home invasion. He was detained, and there was a trial in which a jury found him to be sexually dangerous. So he has not been into the community since the last time that he committed a sex offense, which was in 2003. However, his behavior has been problematic, both when he was serving his criminal sentences as well as during his civil commitment, including multiple disciplinary reports. When he civilly committed, they're referred to as observation behavior reports. But he has consistently failed to cooperate with the supervision of the treatment center staff as well as the therapist, in that he has not participated in treatment. And furthermore, he has continued to act out against the rules of the institution, just as he had acted out against the rules when he was in the community. So all of his actions they're driven by, and the witnesses were particularly focused on the fact that Mr. Zeal is particularly blended with his anger and his violence, and that connects with his sexually deviant and sexual acting out. In fact, in the record, in the supplemental appendix, volume 2, at pages 83 to 85, there was a report by a psychologist at that time. He was being supervised by probation in 1991 for a very brief time, but during that time, the therapist wrote that, in fact, what was most concerning with Mr. Zeal is that by 1991, his offending behavior, his sexual offending behavior was escalating. And in fact, he then was released into the community for about 3 months on a parole. He was returned because of, again, evading a taxi as well as harassing women. He served that sentence, he got out into the community, and he once again committed an offense with which the Commonwealth suggests is certainly much more escalated and the most serious of his offenses, wherein he brought a knife to this visit. He lied to the therapist, told her that he gave a fake name, and he said he did that so she wouldn't know he was a sex offender. He went to her residence at night. He sat and told her that he was there for a divorce matter when he's never been married. He then stayed there for an hour or so, assessing the situation, and then asked if he could go upstairs to use the bathroom. When he comes down from using the bathroom, he has on a pair of leather gloves that he says he bought in the winter. And he testified at this trial that the reason he put the gloves on was so that he wouldn't leave any fingerprints. When the therapist resisted and screamed, this being in May, he heard the sirens, the police had been called by neighbors, and he ran out. But he didn't leave the area. He actually sat there for 4 hours while the police were searching for him, hidden, and then returned back to the home. Upon seeing that there was another car there, he departed. But most significantly, he indicated that this therapist, who she said she let him in even though he didn't have an appointment and was unexpected because she thought he needed help, that he indicated that she was being provocative because she had a skirt on and she was rubbing her thigh.
Where was that testimony that he gave, or is that something he said to the police?
He said that she was being provocative, wearing a skirt and rubbing the thigh to the police. And he did not dispute that when he testified at trial that he said that. So the evidence in this case was more than sufficient for the jury to conclude that Mr. Zeal remains a sexually dangerous person. If I may address the static 99R as it relates to that, in this particular case, there was no error to admit those. Counsel did not object to the admission of the labels. In fact, counsel's strategy in this case was to pursue an avenue in which Mr. Zeal was not a sex offender. He hadn't committed a sex offense in over 30 years, and therefore he wasn't sexually dangerous, that he was awkward, but that he didn't have an antisocial personality disorder, and counsel did not focus in on or object to those labels coming in. So again, there was no error to admit.
George was decided in 2017. I couldn't see much difference between the labels under the revised labels and the labels that were held to be inappropriate in George.
Actually, the researcher, Dr. Carl Hansen, wrote an article that I believe is referenced in the George case. And in that article, they revised the labels, and they tied the labels to the evolving risk estimates that they had seen in the research past the original labels. And so there was a distinction, but even if this court finds that there is not a distinction, Mr. Zeal did not object, and therefore there was no substantial risk of miscarriage of justice in this case. I would say that this case, even if the court finds that there's error, there was not the emphasis on the labels that would cause this verdict to be reversed. In this particular case, in fact, there was limited testimony about the labels. And in addition, the witnesses, they fully explained what those labels meant. And particularly, I would note that the witnesses explained that the risk scores are what they are based upon the items, but that the risk estimates as well as the risk categories are not the specific risk category or risk label for Mr. Zeal, that those risk estimates and risk categories are group estimates and therefore are not his particular risk to reoffend sexually. And that was very clearly reiterated by both Dr. Bell and Dr. Weir. In addition, the jury actually heard from Mr. Zeal's retained expert, Dr. Kriegman, that because he doesn't even feel that the static 99R is a particularly useful tool for the reasons that it doesn't tell you about an individual score, he didn't even use, and the jury heard that Dr. Kriegman didn't even use the static 99R. So I would say that with all of the evidence that the jury heard, that there was no chance that they had any confusion as it related to the fact that that risk label and risk estimates was not specifically saying that that is Mr. Zeal's risk to reoffend sexually. If there are no further questions, I would rest on my brief.
Seeing none.
All right, we are now live and recording.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me on your panel today are Justices Englander and Grant. Each side is allotted 15 minutes. You needn't use all of your time. We don't entertain any rebuttal. If we have any technical difficulties, we'll do our best to reestablish a connection, and no one will lose any time because of it. With that, I'll call the next case, 20P647, Williams versus the Norwell Board of Appeals and others. Mr. Nguyen.
Good morning, Your Honor. It's a pleasure to be back before the court. The case before the court is comes before the panel for the second time. The first Williams 1 came before the panel back in, I think, 2013. And in that case, the panel had established that the right-of-way that Mr. Williams had in the 1948 plan is no other right-of-way than the existing right-of-way today, which is Stony Brook Lane. And it also establishes that the right-of-way Stony Brook Lane crosses over the locus for more than 100 feet. The only thing that was left that the panel had given the board the deference to interpret its own 1942 zoning bylaw. And it gave that deference and sent it back to the land court, which the land court issued that remand order for the board to determine its zoning bylaw. And on remand, after hearing, the Board of Appeals in Norwell had determined that Mr. Williams had a protected lot according to his interpretations of the grandfather provision of Chapter 48, Section 6. What occurred, though, during those hearings before the board was that the board granted Mr. Williams' building permit based on the grandfather provision, but it also decided that there was no bylaw in effect in 1948 when the law was created. This created a whole opening of arguments that leads us to today. It allowed the land court to believe that the planning board had to do an adequacy determination at this point. By the sheer fact that 1942 bylaw did not exist, that for some reason the land court decided now the planning board has a authority and right to do an adequacy determination. The Board of Appeals of Norwell didn't agree with that, but that's where we stand. And I believe it's incorrect for two reasons. One, the exemption under Chapter 41, Section 81F deals with property that had been subdivided prior to the subdivision control laws applicability. In this case, the town of Norwell adopted subdivision control laws in 1953. So
Council, I'm going to interrupt. Oh boy, we got feedback, and that's got to be one of you guys has something on, maybe our live stream. You got to turn it off.
Is it my voice, Your Honor, or?
No, but the feedback now it's off, so maybe somebody's helped it. Okay, so here, there's a lot of complicated questions here, and I want to try to cut through them if I can. Isn't the most fundamental question whether you have frontage under 40A Section 6?
Yes, that is a central question.
That's the most fundamental question. And the land court said that frontage is undefined in the statute, so they're going to look at the Norwell bylaws, and they looked at the 1959 bylaw for the definition. And what do you say to that?
We're focusing on the time period in which the lot was created, not while it travels through time as the changes occurred in the town. The protected exemptions under both the grandfather provision and also under Chapter 41 deals with property when it was created. In essence, it provides protection for bona fide purchasers of a property. So
was there some other definition of frontage that would have been applicable in 1948?
That definition of frontage, we can apply the 2009 definition of frontage, which indicated that any public or private way.
Why would we pick 2009?
That was the year in which the building permit was applied for. So even if we apply the most stringent,
if you pick 2009, you have big problems, I think, right? Because don't you then have to have something that it's either a public way or the planning board has determined it's adequate?
Well, I'm focused on 2009 because the definition does say that it's approved. Any public or private way shown on a plan approved under the provisions of the subdivision control law. So the authority that the planning board has is through Chapter 41, and Chapter 4181 FF gives them that authority to exempt properties that were prior to it. Even their 1943 rules and regulations for the planning board indicated any subdivision plans recorded prior to 1952 is considered a plan approved. So what I'm trying to focus on is that if we look at—
You're saying if you look at the 2009 standard, the 2009 standard would adopt the notion that something that was subdivided prior to 1953, when the subdivision control law came into effect, would be an approved lot. That's the argument?
It would be approved lot because the definition specifically says any private way shown on a plan.
Doesn't it still have to have frontage under 40A?
It does. That frontage under 40, that meets the bylaw definition of way. In Williams 1, it had already been established that the property abuts Stony Brook Lane, and it crosses.
Let me make sure I understand. The 2009 would throw us back to the definition of way that's established in the 1942 zoning bylaw. That's your argument.
My argument is that under any zoning bylaw is still protected, but we're focusing on one that has more definition. Because there was no bylaw.
That argument I fully understand. I don't know why I'm going to 2009. It seems to me that I either want to look at 1948 when the lot was created, or the year before it became the time in which it was next transferred that happened
Yes, there were several transfers, and they were all held in separate ownership. But I guess I'm focusing the court on the sheer fact that the lot is still a protected lot under any zoning bylaw. With that Stony Brook Lane is a way that services 7 other residents, and it doesn't need the planning board to do an adequacy determination.
Whoa, that you're going to lose me there. I mean, the planning board gets to make an adequacy determination. That's what Goldman says. The fact that other lots may have previously been built on is not going to help you, is it?
But it is a protected lot because it was created prior to any zoning bylaws.
Different argument, but let me ask you a different question, because it's not in the briefs, but it is in the opinion of the court. I don't want to get us too sidetracked, but don't you have to establish, in order to get a building permit, that you have a right to get from your lot to a public way?
That was established in Williams 1. In Williams 1, the court specifically indicated that that Stony Brook Lane is the existing way that exists today was what exists in 1948.
But that doesn't mean that doesn't mean you have a right to cross over other person's property on the way to a public way.
The court's referring back to the question of was it the title question? I don't believe that's not before the court.
Well, but it was before I want to make sure I understand. It was before the land court. The land court didn't decide it. It was before the board, and the board basically threw up its hands and said, we can't figure this out. But you know what? We think you have vital access, and that's good enough. Now, maybe that's entitled to deference, but there's a question of title, right? That it hasn't been resolved yet.
It has not been resolved, but that question itself is the only objector. I don't want to get into that too much, because that's a separate question that's not before the appeals court, that wasn't briefed.
Okay.
Mr. Wynn, now I'm confused, because I thought we said in Williams 1 that the lot did have 100 feet of frontage on Stony Brook Lane.
Exactly, it does. And that's
not to cross over anyone's property to get there.
I'm sorry, what was the second part?
You don't have to cross over anyone else's property to get to Stony Brook Lane.
Exactly, because the board, this is based on a zoning question, not a title question. And the board, there was no definition in its NORWELL zoning bylaw that requires actual title. It was vital access that it was granted. And that was what the appeals court in Williams 1 has specifically stated. And the board again deferred that question and said that that's not within their own jurisdiction to decide that matter, because it's not part of their definition.
Councilor, is there anywhere in the record among the various maps and plans that shows the Williams property in relation to the LaRose property?
There were prior titles. I submitted probably about 5 A&R plans that depict the Stony Brook Lane crossing the locust. The prior trial in Williams 1 did have a title examiner go through each and every one of those.
I just can't figure out where the LaRose live in relation to the Williams property.
In essence, everyone's across the street. In essence, Stony Brook Lane provides access for 7 other residences, and they are just across the street from Mr. Williams' property. They're just further up, but everyone's property is across the street.
They have to be in the butter and a butter to an abutter. All right.
Yes. The title examiner did a great job. Again, that was in Williams 1, and it was fully briefed there as well. The question of common title. I'm sorry, Your Honor.
Does Williams have to cross the LaRose property to get to Stony Brook Lane?
In the title cases that we provided, they actually have a common was a grantor, which is Esther McKay. She was the landholder who owned most of those properties back then and conveyed it out. there is a deed straight from Mr. Williams' predecessor in title that grants the LaRue's that ability. That's the hilarious thing about this matter, which we'll discuss in another case, that ability to even utilize Stony Brook Lane. So
it would be really great to minimize some of this since it's only been going on for what, 11 years now?
No, yes, Your Honor. Well, the question is been very expensive. So we're focused on, I think, if he's not protected, then he has to, Mr. Williams has to decide what he wants to do. But yes, there is a common grantor question. It is estoppel by deed in challenging anyone's use of the same right of way that the predecessor in title had granted the butter. So that question is I think a pretty clear, straight answer. But yes, that we would love to have it before the court as well.
So can I just ask, I'm trying to understand, your briefs discuss the subdivision control law, section 81FF at length. And I was trying to fit that into what the land court was addressing. And I think I asked this before, but even if we agree with you about what 81FF does, all that does is say that you're not subject to subdivision control. It doesn't get you out from under the obligation to demonstrate frontage under 40A section 6, right?
It does. Williams once specifically stated that they has over 100 feet of crosses the property for over 100 feet. It meets the minimum requirement of 50 feet. It
has 50 feet, but the question is that frontage, quote unquote, frontage for purposes of section 6, right? And I don't think we decided that in Williams 1. That's what we sent it back to determine whether that was frontage.
Based on the 1942 zoning bylaw. So I do contend that the 1942 zoning bylaw is applicable under case doctrine. But what has occurred is because the 1942 zoning bylaw has somehow been I guess, revoked or annulled, it created this large opening that we're arguing based on a planning board that had not existed yet to determine its adequacy determination.
Well, that argument I fully understand, and what I'm struggling with is the only case that talks about how you construe the word frontage is Justice Cordy's decision in I can't remember the name of the case anymore, but it was a case about Middleborough. But I don't know why frontage in section 6 is going to vary from time to time or from town to town. It seems to me that if we're doing statutory construction, I wouldn't necessarily go that route. So anyway, I'm just musing. I can't wait to talk to your brother.
Thank you very much, Ron.
Thank you, Mr. DeLisi.
Thank you very much. Members of the panel, may it please the court, Attorney Jeff DeLisi, and I represent the appellees Gregory and Mara LaRoe. I had some prepared remarks, but just to piggyback off of the conversation that just occurred, the title question is a question that the Court of Appeals said if the board wishes to investigate that, it can. The board did wish to investigate it. It hired a title examiner, and they were still unable to determine whether the appellant had rights in the road. And therefore, when the decision on remand was issued, not only was the decision on remand appealed, but my clients also initiated an action in the land court on the title question. That matter was pending at the time of summary judgment in this case, and the court continued that matter because it determined that this was the threshold issue at the moment.
Thank you.
So that's that on the title issue. On the LaRoe property, yes, Stony Brook Lane crosses through LaRoe's property, and that was the subject of the title action. Also, on the issue of frontage, the appeal, the what the case law says is that if frontage with the property under 48 section 6, the focal inquiry is whether the property met the then existing requirements of the zoning bylaw at the time that it became non-compliant as a result of the amendment to the bylaw. So the issue was because the question is frontage a defined term, because it's not a defined term under chapter 48 entirely. So the way the courts look at it is they go to the local bylaw definition of the word frontage.
Let me stop you there. That's based entirely on one case that's about 4 years old, written by Justice Courtney, right?
No, I believe that that is fairly established case law that's older than that. I don't have it at my fingertips, but I believe.
Because I didn't see any cites to any prior cases when he makes that statement in the case that I read.
There's a case, Marinelli.
Yeah, that's the one.
That's the one. Yeah. So that you are correct, Justice Englander. That is where the precedent was established by the SJC on that question.
And all he says is we'll look to the local bylaw. But you take that one step further and you say, well, we have to look at the local bylaw from 1959, which is after any of the transfers that we're worried about. Why are we looking at 1959? Why wouldn't we look at 1942, even though it was subsequently invalidated? It was the only bylaw that predates the creation of this lot.
Because the bylaw was invalidated prior to the creation of this law.
So what? If we're going to look for a local bylaw to try to help us define frontage, why wouldn't we look at the only local bylaw that existed prior to the creation of the lot?
Because that's not what the case law says is the requirement. The requirement would
What case law are you relying on?
The case law is cited in my summary judgment brief, which is in the record. I don't have it at my fingertips, Your Honor. But
I have a related question. That we sent it back to determine what the 1942 law required, not whether it was applicable.
No, that's not my read. My read is that you sent it back to determine whether the lot was protected under the residential lot of record exemption in 48 section 6. The remand order, which was consistent with that order, indicated that it was that the ZBA can consider when construing whether it is grandfathered any new evidence. And at the time of that hearing, new evidence was put forward, and the new evidence that was put forward was that the zoning bylaw had been invalidated.
I didn't read it that way. I thought that as far as new evidence was concerned, it was new evidence on what the 1942 bylaw permitted.
The order, I think, is broad, and I think that the zoning board is entitled to deference with respect to how it handled that order and dealt with that particular issue. But we get
to construe what our order and what our decisions meant. We don't defer to what the zoning board thinks our order meant, right?
That's correct, Your Honor.
But we might defer, it seems to me, to a determination by the zoning board that the road provides vital access, quote unquote. Why wouldn't that be a finding that's entitled to deference?
Because the zoning bylaw requires the planning board to make that determination, whether it be the 19.
No, it doesn't. Not for something that's created before the planning board even exists.
The
Because then we're
1959
in, I mean, why are we deferring to something that didn't exist when the lot was created? The purpose of this is not to take away buildable rights that existed before the statutes came into effect. And I can't understand why we're looking at 1959 or why we're talking about the rights of the planning board. And I'm honestly saying this as sort of like, hey, you know, I'm trying to understand the law here. So if I got it wrong, help me out. But isn't that the purpose? That's what 6A is about. It says, you know, if this is done before there was a zoning bylaw in effect, all you need is 50 feet of frontage. And then there's a question, what does frontage mean? And 81FF is saying, if this existed before the subdivision control laws came into effect, and it was already a standalone lot, then we're not going to apply the subdivision control laws to it.
Yeah, but 81FF applies to subdivisions. It applies to plans showing
This is a
subdivisions.
subdivision. This is a division of a lot into more than one lot.
No, the 1948 plan only shows one lot.
Doesn't matter what the plan says. You all concede that the lot didn't exist until 1948. Therefore, it was created from more than one, it was created as a lot. In other words, something was divided into more than one lot in 1948. That's the only way to get a lot, is to take something that's a lot and turn it into more than one lot.
But the bylaw, whether it be the 1959.
So can we agree that it was a subdivision in 1948 under the definition that that something was created that was more than one lot?
No,
Really?
I simply don't agree to that. No, the plan.
So this is the first lot in history that was dropped from outer space? I don't understand the argument at all. I got to tell you, I read that in your brief and I thought that can't possibly be right. The lot is created. In fact, that's what's shown on the plan. Here's a lot that came out of Ms. McKay's property.
But
property existed, and then the next day in 1948, it was more than one lot.
But 81FF applies by its language to the effect of the subdivision control law on plans showing subdivisions. And what we're dealing with here is not the subdivision control law. We're dealing with the Zoning Enabling Act and the zoning bylaws in the town of Norwell. And that language doesn't say, so far as a plan showing a subdivision recorded is affected by the Zoning Enabling Act or local zoning bylaws. There's good case law that separates the subdivision control law from the Zoning Enabling Act. Just look at the Nantucket case with
you don't have to tell me on that.
Yeah. So the zoning bylaw is where we start this, and I understand Your Honor has a question as to which zoning bylaw are we looking at. But if 1942 is invalidated, if it was annulled, then you can't look at it, and you have to, since it's
Mr. DeLisi, let me read to you from the 2014 remand order. In considering whether the locus met the then existing requirements of 1948, the board will need to consider whether the locus met the then existing frontage requirements. It doesn't say anything about whether they're applicable or not. It's then existing, and that's the 1942 law, right?
No, it's at the time that the increase in the frontage requirement was passed. So if you look at the very beginning,
the law was created, from space or not, in 1948, right?
Yes.
And what were the then applicable bylaws?
There were no bylaws at the time.
There was the 1942 bylaw.
No, it had already been annulled.
So if there's no bylaw.
No. It was. I thought it was annulled in the 50s.
No, it was annulled in 1947, the year prior to the creation of the lot.
So if there's no bylaws in 1948 when this lot was created, why isn't there no frontage requirement except for the emergency access that the fire chief has already said and the board found was sufficient?
There was no frontage requirement until 1959.
Well, but why is 59? Why does that matter?
Because it was at that zoning bylaw that the requirement was first adopted that it has to have frontage of at least 40 feet if it's 2 acres. And this is more than 2 acres. So it was at that point in
Okay,
time.
so in 59, the lot becomes non-conforming for the first time.
That's
Up
correct.
till that time, they had a buildable lot?
Yeah.
So
Okay,
is your client's position that Mr. Williams owns this 2+ acres of land that's adjacent to or near their land, their property on this cul-de-sac, and Mr. Williams just can't build on it, so they get to enjoy the open space and the trees and the benefit of his empty lot that he can never build on?
No, our position is that the zoning board of appeals was incorrect to call this a protected buildable lot.
which there's very little difference between those two because you're going to go to whoever you can and say he can't build on it, right?
We don't think it's a buildable lot. So if somebody else were to come along and buy it.
And it was a buildable lot in 1948, and you're saying that in 1959, when the bylaws made their change, that it became unbuildable. And the problem I have with that is that it seems to me is exactly what Section 6 and Sections 81 FF are all about.
And then, but you need, under the zoning bylaw, in order for it to become buildable, you need either a way on a plan approved by the planning board.
Well, what you're telling me now was not in 1948, right? That didn't exist in 1948, because you're reading to me the definition from the subdivision control law, which wasn't enacted, or, well, it was enacted, but it wasn't applied to Norwell till 1953.
That's correct. And in the 1953 application in the town of Norwell, the word subdivision was defined, and it was defined as a plan so as to require the provision of one or more new ways as opposed to a way in existence. So even at that juncture, under the local subdivision regulations, which are more restrictive than the subdivision control law, we still don't meet the definition of subdivision. I think this case comes down to whether the land court was erroneous in invalidating, in applying the in determining that the 1942 bylaw was incorrect. And then it comes down to whether planning board action is required. If the planning board acts and says that this is sufficient, then I believe that it's a buildable lot. But that's something that I think is required. And my brother admits, and he talks about 2009 as being the focal date of the zoning bylaw here.
He was very clear even today in saying, look, I don't have to rely just on 2009. My point is that if you look at the sum total of what's happened here, this was a buildable lot that is no longer a buildable lot, and that's improper under the law. I heard him say that.
I see that my time has expired.
Okay, thank you very much. Thank you both. We'll take this under advisement.
All right, and it appears we are now live and recording.
Welcome to the appeals court. I am Justice Meade. With me on your panel today are Justice Englander and Grant. Each side is accorded 15 minutes to make your argument. You needn't use all of your time, and we don't entertain rebuttal. This case is impounded, so please use pseudonyms or other indicators other than names. If we run into a technical difficulty, we'll do our best to reestablish contact, and then no one will be deducted at time. With that, I'll call the next case. It's 20P446. John Doe number 526277 versus the Sex Offender Registry Board. Mr. Campbell.
Good morning, Your Honors. May it please the court. I'm Attorney Brandon Campbell for John Doe. I'd like to start with my arguments related to the risk prong, starting with the hearing examiner's finding, and I quote, "There was no evidence to show that Doe is now capable of appropriately managing his social relationships." Your Honors, that finding is not only flat out wrong, it is contrary to all of the evidence in the case, and it is in and of itself, it's grounds for reversal. The whole point of having expert evidence in a case like this is to fill in the blanks where a layperson, the hearing examiner, needs to be informed about autism, because that is what the evidence was in this case. The evidence was that the autism that Doe suffered from was a causative factor in his offending behavior, and the expert testimony was necessary to answer the questions of how did autism affect this case? Can Doe change? And if he can change, at what rate can he change? And frankly, Your Honors, I find this finding astonishing, because in a whole, where everything comes down to whether or not Doe can move past his developmental disabilities, to say that there's no evidence that he can do that, which is how I read this, when the evidence showed that expert testimony says that he has overcome his cognitive distortions through experience and counseling. That was Dr. Saleh. Dr. Nestor said that Doe was sincere, remorseful. He had the capacity to learn from his mistakes, and he now understood the seriousness of what he had done and how it was wrong. His therapist submitted evidence to the same effect. And for the hearing examiner to say that there's
Suppose instead of using the words no evidence, he'd simply said that the evidence does not show. Would you be making the same argument?
Yes, I would, because I think it's said best in the Doe, it's at 483 Mass 131. The board must have explicit and objectively adequate reason to reject uncontradicted expert evidence. Now, I know my brother argues that the board hearing examiners are not required to accept expert evidence, and that is the baseline. But the deeper question here is, did the hearing examiner reject it on a proper basis? And the hearing examiner didn't even acknowledge it, which is, when you take all of that away, you take out all of the science, then you're left with a hearing examiner that's essentially making a finding that this person is autistic, so he might do something again. And I think the panel can appreciate.
Respectfully, counsel, respectfully, I understand your argument. And I understand where it comes from. But there's more to it than the hearing examiner simply applying his own views. The evidence is, he talks about that that Doe is isolated from the community. Those are facts which seem to be agreed on by everyone. That Doe is at home, and that he doesn't go out, he doesn't drive. In fact, you emphasize some of these points because I think you say this suggests that he's not a risk, and that he sees a limited number of family members. And there's a statement here on page 23. All the evaluators concluded that his diagnosis, which also contains social attributes of immaturity and lack of understanding regarding relationships, is lifelong, and his relationships must be monitored in his therapy. Now, it seems to me that those findings relate to his statement that there's no evidence to show he's now capable of appropriately managing his social relationships. Perhaps overstated, given, as you point out, that there is expert testimony that at least shows some evidence of that. But what do you say to the general statement that I read to you from page 23? This is a problem that's lifelong. He is isolated right now.
Exactly. That's a great question. Thank you, Your Honor. It's nobody. There's no nobody's debating that autism isn't curable. That's not what we're here to review. It's what is his risk of reoffending sexually, and as part of that, you have to look at his developmental issues and how that impacts and his ability to understand and grow and move forward. And all of the evidence was that he had expressed profound remorse in this case, and that he had felt terrible about what had happened, and he understood now how it was wrong. And that's why we needed expert evidence in this case to show that. It's not about whether or not autism is lifelong. That's just
along those lines, I saw something in the record somewhere that he has, among his diagnoses, is obsessive compulsive disorder. And there was evidence that he repeatedly telephoned or texted this victim and required her to respond very quickly and was sort of obsessive about these contacts. How does that evidence relate to the current controversy about factor 2? If he's compulsively contacting the victim, does that relate to the evidence that he's compulsive in his sexual behavior? Or what should we do with that?
That, as I recall from the record, that was a suggestion that was made by Dr. Bell. I do not believe that he considered it. I don't remember him saying applying that full on. The other Dr. Saleh did not make that finding. The therapist did not make that finding. I do not think that there's enough evidence there for the hearing examiner to find that he suffered from that. And the compulsion in the context of factor 2 that we're talking about, is not a compulsion. Is he going to make things organized and neat or call his girlfriends like it's whether that plays into his offending behavior. And actually, and I'm aware of the recent case from the appeals court on this issue, and I'll be interested to see if the SJC decides to take that on further appellate review. But in this case, I believe that case left open the issue of a fact-based challenge to compulsiveness. And in this case, the compulsiveness in factor 2 is based on a time to think in between the offenses.
Have you had a chance, counsel, to take a look at the decision from Judge Wilkins in the Superior Court, in which he says that factor 2 is invalid?
I have, Your Honor, and
Okay.
Frankly, there's no science to support that definition of compulsiveness means anything. But in this case, where we have a person who does not know that what he is doing is wrong, he believes that there is nothing wrong with him having this relationship with this underage person. The only reason he's not telling his family is because he believes that they will have a problem with it because they're related. But compulsion is about, I must, I can't stop myself. That's not what was going on here. He thought it was fine.
Contacts with the victim. So that's what I'm having trouble kind of separating. If he had a clear compulsion to have constant interaction with the victim, but maybe that's not a compulsion under factor 2 because it's not compulsive sexual behavior because he's able to control himself long enough to hang up the blankets.
Yeah, I think, Your Honor, it's not a compulsive that relates to the sexual misconduct, and I think that's what's important for factor 2.
I have a factual question for you that was bothering me, and it's related to what you just said. You said, and you put this in your briefs as well, he didn't think what he was doing was wrong. He only thought that there was an issue because she was related to him. But there's also evidence, and there's a finding, I think, that he, before there was any report to the authorities, when she first told her family, he texted her words to the effect of, do you know what they do to people like me in prison. That, it seems to me, is an indication that he knew that there was a criminal aspect to what he was doing.
At that point, it's inferable that he is becoming aware that there could be some criminal consequences at that point. And yes, he was probably at that point afraid that he was going to go, that he could end up in prison at that point. But I think you're, with all due respect, Your Honor, you're making some leaps on the evidence that aren't there.
Well, I'm trying to reconcile two things that don't seem to reconcile, because he made that statement before he attempted suicide and before she ever went to the police.
The record,
unless
is not,
you correct me, unless I don't understand the record.
Well, the record isn't detailed enough to know exactly a blow by blow of what was said to him in between the disclosure from the victim to the family about his exposure.
And his
yeah, that's
okay.
all
I take
wide
the
open.
point.
And back to your and just to touch briefly on your point, Justice Grant, the compulsion in factor 2, I believe, is really trying to get at whether or not there are things in the nature of pedophilia or paraphilias that would indicate a higher likelihood of reoffending. That's why it's a high risk factor. Those types of inquiries are what the compulsion is getting at.
It just seems to me, and maybe this is, I don't understand Dr. Hansen's expertise and Judge Wilkins' ruling well enough. It just seems to me when someone repeatedly offends against a child for this long under the roof of these relatives, that seems so much worse than an adult who offends against two different adult women years apart. That's just a comment.
Yeah, there's many things in the sex offender research that are counterintuitive,
Right.
Your Honor. I wanted to go back to Justice Englander's comment about the living situation lacking stability. I vehemently disagree with the correctness of that finding. Not only just on its face of the regulation, I think he met it. He got no mitigation under that, but we've submitted evidence that he was on SSI, so he's getting money coming in. He had health care through Medicaid. He had a stable place to live. There was no drug or alcohol issues. And he was not isolated. He's surrounded by his family. He's got a stable place to live. He's going to counseling. He's checking in with probation. There was evidence that if he did more, it would be counterproductive. And that's why it's important to have expert, because sometimes—
Which way does that cut? I mean, the finding is isolated from, look, I mean, I think the concern that is being articulated by the hearing examiner is he may be stable now, but he's 30 years old. He's not leaving the house much. How do we know what will happen if that changes?
And I have a question on that. As to internet publication, I know that SORB usually argues there needs to be internet publication because this is high risk of reoffense. What about the fact that his isolation and his playing video games and his apparently showing porn to the victim means that his most likely social outlet would be on the internet? Does that give more grounds for internet publication?
Well, first, with respect to Justice Englander's question, these we're really looking at the immediate future. We're not supposed to be like figuring out the rest of his life. He's entitled to, in general, move for reclassification every 3 years. The board can move sooner if it becomes aware of knowledge that will change things. So we're really looking at the circumstances on the ground right now, and I would submit that he is in the best situation stability-wise that he can be in. He's in a great for him and his needs. More could actually destabilize him and be counterproductive. And I'm sorry, Justice Grant, could you hit me with your question again?
Internet publication, how does the social isolation exacerbate the need for internet publication?
Yeah, so with the respect to the, and I believe that there should be a remand for consideration of 496501, but past his prologue is what that case says. The inquiry is, what is it, look at what he's done in the past and what is that likelihood of that happening again? He's not an internet guy. There's no evidence that he went on the internet trolling for people. This was a situation where he was very close in contact with a family member who had who was mentally on a similar level as he was. He's got a child's mind. She's a child. He's in an adult body, and that's where things went wrong here. And you need to look at the likelihood of that.
We're going to have to leave it at that, Mr. Campbell. Thank you, Mr. Grogan.
Thank you. May it please the court, Patrick Grogan on behalf of the board. Regarding the expert opinions, the hearing examiner considered them, but there was contrary evidence, specifically from the testimonial letters from the family members as well as the mother. It's been discussed quite a bit already that it continues to be in an isolated area in the body with his mother within the house. The fact that he's getting paid is not a mitigating factor. And I think Justice Grant's point has some merit to it, that his outlet is video games and internet, and that's where he is likely to find his newest victim. Now, regarding factor 2, now the board defined, as the expert in the field, defined the threshold inquiry weight for having the opportunity to reflect on the wrongfulness of something and then nevertheless compulsively continuing to do it. Here, I suggest to you that there's ample information of his compulsiveness that continued for nearly 4 years and escalated. This is not an individual who just touched her occasionally. He completely escalated into penetration offenses and penetration with objects. So I think another point that Justice Grant, I believe, and maybe Justice Englander brought out was the attempts to conceal it. And this goes to his knowledge of knowing that what he's doing is wrong. At various times, first of all, it was not just in his house. He did it in a hotel.
Can I just stop you?
Yes.
Right now, factor 2 has been declared invalid. We don't even know whether that's going to be appealed. Shouldn't we wait to find that out? If the factor 2 finding falls, that affects how this case would be decided, right?
I disagree. And
Why?
I'll explain why in a moment. First of all, if you look at Justice Wilkins, and yes, no decision has been made at this point whether or not that's going to be appealed. If you look at Judge Wilkins's decision, he affirmed that level 2 finding in that case, even though he found that factor 2 was improperly applied. So the fact that factor 2 was applied with threshold weight is not fatal to this case. In addition to that,
if you take away factor 2, the only thing that's left is adult on a child, right?
For statutory high risk factors, correct.
Yeah.
But there's also factor 19.
And I think everybody agrees that in this case, his mind was not really an adult mind, right?
You know, the problem I have with agreeing with that statement is the fact that prior to the offending behavior, during the offending behavior, and after the offending behavior, he was always in treatment. He was always in some sort of therapy. And it didn't help him or stop him or change his mind regarding this being a wrong offense. Now, he can self-report all he wants that I didn't want to tell people because I was afraid it was a family member. But I think his efforts to conceal it when there are other children in the room, and I will speak in a moment about his conduct after he was confronted with this, speak to volumes of that issue. I mean, it's very concerning that once he was confronted with this, he immediately starts harassing, frankly, the victim repeatedly over texts. You know what this is going to do to me. I suggest that the inference that the hearing examiner made in this case, based on this evidence, is a fair inference and a preponderance standard for subsidiary facts, that he was aware of the consequences of his action and was basically attempting to get the victim to not put him in trouble. In addition to that, he then attempted unsuccessfully suicide. I think all of that goes to the state of mind of knowing how wrong this was. Now, this information and this conduct that would be considered under factor 2 doesn't go away just because the threshold inquiry of factor 2 may be declared invalid and may stay as invalid. It would still be applied under the board's factors, specifically under factor 37. Factor 37 states you can consider information regarding the nature of the sex offending behavior. To argue that because factor 2 has been invalidated, and that's where the hearing examiner in this case actually applied the information, that therefore the hearing examiner is not allowed to consider that for 4 years, he continually molested an 11 to 15-year-old child, got increasingly violative of her, penetrated her with objects. It strains credulity, basically, because ultimately that goes to the heart exactly of what the board is trying to find out, his likelihood of reoffense and the danger that he poses. So there is a factor that information would be applied to. Obviously,
okay, so if the board is trying to, so I have two questions for you, or two different areas that I'd like to ask about. If the board is trying to find out likelihood of reoffense, wouldn't it be relevant that there were 3 people who were professionals who examined this particular individual, all of whom determined that that risk was low, including Dr. Bell, who was retained by the DA's office?
Is it relevant? Is it considered? Yes, the hearing examiner considered it.
Well, I didn't see any mention by the hearing examiner of Dr. Bell. I didn't see any mention by the hearing examiner of Dr. Nelson on this subject. I didn't see a recognition by the hearing examiner that all of the professionals who examined him determined that his likelihood of reoffense was low.
Well, I believe that's because they didn't testify at the hearing and they didn't consider their ultimate risk opinion.
Okay, he didn't say that, but I understand the point.
But those are the regulations, and the hearing examiner obviously is aware of the regulations. So considering that information under factor 35, which is one factor among 38, is what the hearing examiner did. And of course, the case law, and I cite to it, is very clear that the hearing examiner is not bound by these opinions of the self-reporting of the individual to...
It's not bound, but I don't know. Okay, sorry, go ahead. I'm still back on the experts and you were moving on to a different point.
No, I think I was still on the expert point. Just that he's not bound to accept the opinions of the expert. And again, you had contrary information from the mother.
What was the contrary information from the mother?
About his current lifestyle, about how he was still isolated, how he was, she testified at the hearing.
How is that contrary to what the experts say when they say low risk of reoffense? The fact that he's isolated?
Well, again, the only risk of reoffense would be the one who testified at the hearing, that the hearing examiner considered. And yes, the fact that he is in the exact same situation that he was when the offending behavior occurred goes to the heart of the hearing examiner discounting that he's low risk. That in application of the board's factors on this fact pattern.
What do you say to your brother's comment when I asked him sort of what I think is the gist of what the examiner was concerned about, which is he's isolated, he's 30 years old. How do we know that's going to last? And how do we know that tells us that he can handle relationships if it doesn't last? And your brother said, well, we have to really look at the current circumstances. We can't think about what might happen in the future. What do you say to that?
Well, the entire purpose of the sex offender registry is looking into the future. I think trying to parse how far into the future, there's no way, there's no definition of how far you look into this.
That was what I was going to ask. Is there any case law that tells us? Because one of the things your brother says that rings true to me is that this examiner gave no weight to his current circumstances, even though his current circumstances, if they were to maintain, would seem to me to be really important in mitigation. He's not having contact with anyone else other than a handful of people that he knows.
He's not having direct physical contact at the time of the hearing. However, this goes to the point of the internet and his ability via the video games. And again, he is going out to therapy sessions. He is going out. He is in the community. He's not going out as much as another individual maybe.
Well, that's contrary to the statement that the hearing examiner found and relied on. He remains isolated from the community.
He does. Okay. And again, I don't want this to be confusing, but he is isolated within his house, but he doesn't, it's not that he doesn't leave the house. He has his therapy appointments. He has his probation conditions. So he does leave the house. He just usually leaves the house with his mother. But he also has his outlet through the video games and through the internet, which is another way not only to meet people online, but ultimately to arrange, if therapy is going well and he starts branching out, arrange to meet people in person in real space and time. Continuing on, so factor 37 would give the...
That's a way of saying that you think that the finding of the hearing examiner that gave no mitigating weight to his current circumstances or the stability of his current circumstances was based on substantial evidence.
Correct. Plus, I would point out that he got substantial, the hearing examiner applied mitigating weight to factor 33 with his home and support system. So sometimes it's hard to parse those two out specifically, 33 and 34, but he got no weight for 34, but he got weight for 33 because he does have a support system. His mother is there. He does have the house. That's where counsel is going with he's, has the money from SSDI. He got credit for that mitigating factor. He didn't get it under 34 because he's basically in the same situation that he was when he was offending for 4 years and escalating against a child victim.
How about where your brother started his argument? The statement, there is no evidence to show he's now capable of appropriately managing his social relationships.
That's based on the mother's information. And I cite to it in my brief, and the other family members' letters. His isolating behavior, his basically staying in the house except for the appointments. That's where the information comes. I mean, granted, those wouldn't be the words I would choose. I would instead say that there's conflicting evidence from what is self-reported to the purported experts. I'm very concerned, and the board was very concerned with his actions once confronted. I mean, I think that goes to the heart of the matter of his compulsion, the way that he addressed these issues, the way that he harassed the victim, the child victim, and the escalation in this case. This is a case where the board's position is remand is unnecessary because, first of all, clearly this is a repeat contact offender. 496501 specifically recognizes that is a specific case that may not require remand for the consideration of that. Now, looking at his actions after being confronted, go to the heart of the potential risk of reoffense and his dangerousness, frankly. His risk of reoffense, he did this for over 4 years and escalated on a child. The danger, I mean, what he actually did to this child and continued to do and escalated on the child, the potential harm for another child victim. Again, this started at 11. And I would suggest to you, if you look carefully at the hearing examiner's decision, you'll see where the hearing examiner notes that pursuant to what Dr. Saleh said, that the hearing examiner was not applying the highest weight to factor 3, because Dr. Saleh said that the petitioner had said that the victim was pubescent at the time. I suggest to you that the information really and the board's factors state otherwise, but the hearing examiner, I believe the exact words were an abundance of caution, didn't apply the highest weight there. So I think that's important to see the lens that the hearing examiner is actually crediting this evidence and looking at it. So there's a direct reference to an example of taking a statement from Dr. Saleh that's not supported anywhere else in the evidence and is only stated by the petitioner in that report, and ultimately giving the petitioner that credit based upon Dr. Saleh's testimony. So there's ample information throughout this decision where it shows that the hearing examiner considered these reports and adopted some of the findings, but not all of them and not the low risk, based upon the facts of this case, based upon what was done to this child, and based upon application of the board's factors. And unless there are any further questions, I would rest on my brief.
Seeing none, I thank you. I thank you both. We'll take this under advisement.
All right, we are now live and recording.
Good afternoon. Welcome to the appeals court. I'm Justice Meade. With me in your panel today are Justices Englander and Grant. Each side is provided 15 minutes. You needn't use all your time. We have read everything. We do not entertain any rebuttal. If we run into any technical difficulties, we'll do our best to remedy those and reestablish a connection, and no one's time will be taken away. With that, I'll call the next case 20P717, Massachusetts Housing Finance Agency versus James E. SPALT. Mr. Dunbar.
Thank you, Your Honors. May it please the court. My name is Ronald Dunbar, and I represent the appellant, James E. SPALT. And for purposes of today's argument, I will be referring to him as Jamie to distinguish him from his dad. And I think it's important in many respects to distinguish Jamie from his dad. This case has a long history. It was filed as a collection case by MHFA in 2012 against James, the father, to collect on a judgment they received when he defaulted on a loan to build a condo development. Shortly after the lawsuit was filed against James, the father, in September of 2013 and December of 2013, injunctions and TROs issued. And it's the language of those injunctions and TROs that I think is critically important in this case, Your Honors. And at that time, Jamie was not a defendant in the case when those orders issued. Subsequently, in June of 2014, and that's the order that's really at issue in this case, the injunction was further expanded. And for the first time, Cape Coastal Marine was added to the injunction. And still, as of June of 2014, Jamie was not a defendant in the case, was not named in the order. It was not until November 19th of 2014 that Jamie was finally added to the case. And I think the critical issues, Your Honor, with respect to the order that we're talking about today, the June 24th, 2014 order, is that if you look at the terms of the order, it applies to the assets of James, the father, and Kristen, the mother. And what we're—
But it doesn't, Mr. Dunbar, but it's not limited to them. It also includes their officers, agents, servants, and employees, and serves Jamie as one of those anyways.
Right, and I think the argument I'm making now, Your Honor, is that the property that cannot be transferred is the property belonging to James, the father, or Kristen, the mother. And the complaint for contempt we're talking about today, which the order issued from, related to Cape Coastal Marine's funds that were in several bank accounts down in New Orleans, where Jamie at the time was an employee of Cape Coastal Marine and was paying the ordinary operating business expenses of Cape Coastal Marine. And it's those funds that came out of that account that Judge Giles found were in violation of the order. And my first argument is the order doesn't prohibit the transfer of Cape Coastal Marine's funds while it's operating its normal business. It prohibits the transfer of James, the father, and Kristen, the mother's assets, whether it's—
But the judge also found that Jamie had actual knowledge of the TRO and the injunction.
But with respect to that, that's the second part. Because Jamie was not in party to the injunction, Judge Giles was required to make a finding that he had actual notice of the injunction and that he knowingly assisted his dad. But with respect to actual notice, Your Honor, Judge Giles didn't find that Jamie had actual notice of the June 24th, 2014 injunction, which is the one that's critical because that's the first one that added Cape Coastal Marine at all. Judge Giles had found that Jamie, when he was served about 6 months earlier in January of 2014, he had notice of the September 5th, 2013 and December 11th, 2013 order, which does not have Cape Coastal Marine as a listed entity. And that's what's so critical, because with respect to contempt, it's got to be a clear and unequivocal violation of a clear and unequivocal order. And that's the whole thing here, is that because Cape Coastal Marine was not in the earlier orders, which there's no argument Jamie was served.
But then he's made a defendant in the case in November of 2014. He resists in 2015 efforts to have discovery taken in Louisiana, and there's an explicit finding by the judge that that the lawyer was aware, the lawyer that he that he was involved with was aware of the modified injunction in 2015. What do we do with that?
Your Honor, with respect to, I think we have to really focus on the fact that this contempt complaint is for the spending of Cape Coastal Marine's funds on ordinary business expenses.
That's a different argument. So you make two arguments. One is my client didn't know. It seems to me that with respect to that, you've got an incredibly uphill battle based on the judge's findings and the basic history of the case, which include, by the way, I believe a second contempt filing, which I believe your client was served with, which took place after the 2014 order was entered and references the 2014 order. I was trying to piece my way through that this morning, but that's what I think. But that's a problem for you, it seems to me, with respect to actual notice, is the finding to the judge. The other argument you're making is an argument about what the order prevents, right?
Yes.
Okay, but that order says James SPALT individually or in any other capacity, including as the registered agent and manager of Cape Coastal Marine. Now, how are we going to read this order so that it's not preventing him from transferring Cape Coastal Marine property? One of the bullets down there is any and all personal or real property in which the above named defendants have a legal, equitable, or beneficial interest.
So, Your Honor, I think that's exactly right. We have to go down to the bullets. I'm not arguing. So in the James SPALT expansions of this order over time, it was always expanded to say, we don't care what capacity James SPALT is acting in, individually, as a trustee of a trust, as the manager of an LLC. He cannot transfer his assets. And I think that's why it's important to go down to the bullets. And the third bullet, the assets belong to Cape Coastal Marine. There's no evidence that James SPALT was entitled to the cash in Cape Coastal's bank account over and above the creditors that were paid. And that's the real gist of this case, is that it's not like Jamie was taking millions of dollars and transferring it to his dad or to himself. He was paying the operating expenses of Cape Coastal Marine. And there's no evidence.
For some of it, and for others of it, it sure as heck doesn't look like it. It was going to himself or to his mother.
Personal expenses.
Personally, yeah. And his testimony was, and I don't see how it could be disputed. He had worked there for several years as a sales rep and brought in very good contracts for the company that were beneficial to the company, and was just getting paid for his time. And in other instances was fronting expenses when he was on the road because he was traveling and got reimbursed. So, but the lion's share, I'd say, over 99% of the funds were funds that were used to pay the operating expenses of Cape Coastal Marine. And that's why I focus on those 3 bullet points at the bottom of the June 24th, 2014 order. It doesn't say you can't transfer the assets that belong to Cape Coastal Marine. And I think because the nature of the proceeding being a contempt proceeding, if it's not clear and unambiguous defiance, if the ambiguities are construed in favor of Jamie, and there can't be a finding of contempt if there's doubtful disobedience or a doubtful order. And I think with respect to Cape Coastal Marine and the role that Jamie was playing, an employee, that I think it is doubtful. There's also evidence in the record, Your Honors, that the checks that were even written weren't written by Jamie. There was a signature stamp. He was on the road and the dad testified.
Yeah, but there are findings of the judge that your client was in active participation with and knew about what James SPALT was doing with respect to Cape Coastal Marine. How do you get around that finding?
And I don't think we need to, Your Honor. I do think that Jamie did testify himself that, I knew that we were spending Cape Coastal Marine's money. I just didn't think there was anything wrong with that because I knew my parents were tied up 6 ways to Wednesday, but I didn't realize.
But Mr. Dunbar, if he aids and abets the father who's enjoined, Jamie testifies himself that he authorized his father to use the signature stamp to disperse money from CCM.
Correct, and I think that's where my argument really focuses on, one, the actual notice, of the actual injunction, and two, the knowingly part of it. I mean, you have to make definite, the case law said, definite and intelligent, conscious decisions.
Well, Mr. Dunbar, I mean, along the lines of what Justice Englander was saying, you have findings of fact here that he knew and his actions were construed as aiding and abetting the father, and all your brief offers are denials of that. That's not a legal argument to say the findings are clearly erroneous. You don't make that argument.
Well,
your brief argues the matter to us as if we were fact finders. We are not.
I understand that, Your Honor. What I'm saying is the fact that Judge Giles had hung her hat on is a fact that doesn't lead to the conclusion that Jamie had knowledge of the June 24th, 2014 order, because her finding was he had knowledge of the two prior orders, which don't have Cape Coastal Marine as a party to it. So,
no, I mean, no. She specifically says that in 2015, he was the only person talking to a lawyer who knew about the, quote, modified injunction. That's her finding.
And there's other, and I think that's clearly erroneous, Your Honors, because there's evidence.
You didn't make that argument that it was clearly erroneous. You didn't talk to us about what the evidence was on that so that we could evaluate whether that finding is clearly erroneous. Instead, I go and I read her findings and I say, jeepers, looks to me like she found that he had knowledge.
Right, and Your Honor, I think she really focused and hung her hat on the knowledge being that he was served with an earlier complaint before Cape Coastal Marine was a party. I get that she talks about he hired a lawyer in a discovery dispute, but that was the focus of that was not Jamie writing checks or anyone writing checks out of Cape Coastal Marine's account for the payment of ordinary business.
But didn't he hire the lawyer to create a carve out from the order that you say he has no knowledge of?
I believe, Your Honor, that the carve out related to the order before the June 24th, 2014 order. I think the carve out discussions came with respect to the September 2013 and December.
Which led the judge to infer that throughout he knew what was going on.
Right, and I think
she so found. She totally discredited pretty much everything that your client testified to.
Yeah, yes, that is true, Your Honor. I think
and it seems to me that it's hard to have an issue with that, since she found that his father had agreed that he had gone into and testified and lied extensively. And then she said, and I found the son to be essentially the same in terms of his credibility. I mean, that's a problem for you, isn't it?
It absolutely is a problem, Your Honor. And I think, if I represent, well, I wouldn't represent the dad, the admitted perjurer. But if you look at the judge's findings, she said, his testimony and his deposition doesn't comport with his testimony on the stand. And the example she used, there was no doubt at his deposition, Jamie was just defiant because, quite frankly, he was upset with how his parents were being treated and said, I don't know the name of my girlfriend. I don't know where I live. I mean, it was silly.
Okay, I understand you have a difficult job, counsel, because you're representing somebody that you now have to admit was a perjurer. Okay, and that's and we know that that's what's going on, but it makes it awful hard for you to say my client testified to X, therefore you should accept it.
Well, I didn't say my client was a perjurer, Your Honor. I was talking about James, the dad. I'm
no,
saying that
you were just talking about your
the judge did find that the apple did not fall far from the tree.
Yes, and the part of the problem with almost sharing the exact name is I think that he was caught up in the shenanigans that his dad had created over the last almost 10 years. But I think that, you don't even have to believe.
Can I ask a question, counsel? Have the SPALTs or any of their entities paid any of the initial $7 million judgment that was entered in 2010?
Your Honor, I believe that, well, I know money has been collected through various means. Jamie, my client, has not paid anything towards the contempt judgment, but I do believe the underlying judgment against James SPALT, there have been, whether voluntary or involuntary, payments towards that through the sale of homes, the collection of checks that were distributed to trusts and alike. but I'm not sure if anything voluntary was ever paid by James.
Thank you, Counsel.
Thank you, Your Honors.
Thank you. Mr. Curran.
Good afternoon, members of the panel. Please the court. My name is Thomas Curran. I represent Massachusetts Housing Finance Agency. This case and this appeal derives from a matter that has been has a tortuous history. It started with a Superior Court case on a liability matter, which ended in a judgment against Mr. SPALT for $7 million, give or take. And then there was a second case, a recovery case, an asset recovery case commenced by Mass Housing to attempt to collect monies on that case. I will say that in answer to Justice Englander's question, there has been some money, very little, recovered from some of the co-defendants in the case. And Mrs. SPALT, who is also a defendant in the recovery action, has filed bankruptcy, and her bankruptcy trustee has recovered some small amounts of monies through a liquidation of property, but the SPALTs themselves have never paid any monies towards that $7 million judgment, voluntarily or otherwise. So this appeal derives from that underlying case and the 3 contempt complaints that were brought in the Superior Court under the recovery action. And this all derives from the SPALT family's actions and conspiracy to convert all of Mr. SPALT's assets, monies, and earnings through these related family entities, and siphon off.
Mr. Curran, can I ask you a question, Mr.
Sure.
Is Jamie bound by the June 14th modified injunction because he's an agent, employee, servant, or an active concert with Jane Kristen?
He's bound by it in several ways, Your Honor. He is bound by it because under the express language of the injunction, he is a manager, and the judge found that he's a manager of Cape Coastal Marine. He's a manager of the other entities. So any entities that are mentioned in that order, he's bound by the express language. He's also bound by the language under the statute that binds any officers, agents, and any parties acting in active concert with the party, the contemptor, which would be James G. SPALT. So he's also bound by it because the judge found clear and convincing evidence that he acted in concert with his father.
Was there any direct evidence that he was served with a copy of the modified injunction?
Yes, there was. Well, he was served with the. He was served with the
earlier injunction in January of 2000.
January 2014, and then he was served in November 10th, 2015. He was served with the second amended complaint, and that included the amended injunction. The injunction was amended in June of 2014. So when he was served in November 10th, 2015, with an amended contempt complaint, which was against him, Your Honor. You read that correctly. It was against him and his mother and his father. Now
and that had the injunction attached to it?
Yes. And that complaint, and it was based on the injunction as well, the allegations in the complaint. The reason why that second amended complaint didn't go to full hearing was Mrs. Spalt filed for bankruptcy. And that action was stayed for a period of time. And so the plaintiff.
Yeah, I wish, I wish you'd actually made that point in your brief that you just made, which is that the injunction was attached to the second contempt complaint, with which he was served. Okay,
Right.
That's helpful.
Yeah.
What about their argument on the language of the injunction itself?
The injunctions don't enjoin assets. Injunctions enjoin people, and they enjoin people from taking acts. And the injunctions are and there is only one injunction. They make this argument that there's 3 injunctions. There's a temporary restraining order, which was converted into an injunction by Judge Troy, which was then modified. It's all the same language. It's explicit that these actors, Mr. Spalt, Mrs. Spalt, and Jamie Spalt, as an officer of the entities, are enjoined from making any transfers in any of these entities.
Well, in order to get to what you just said, the words above named persons,
right,
in the 3rd paragraph has to include Cape Coastal Marine.
Right, and it does. It includes James Spalt as manager of Cape Coastal Marine. How could he otherwise transfer assets from Cape Coastal Marine other than in his capacity as manager? And that's
all
what
of those
Judge Hogan
officers, agents, servants, employees, attorneys, and those persons acting in active concert or participation with the above named person. And you say that's not James Spalt and Kristen Spalt, that's James Spalt, Kristen Spalt, and these other entities that are identified.
It's specifically James Spalt and Kristen Spalt, and James Spalt and Kristen Spalt in their other capacities. So, and specifically in their capacity as manager of Cape Coastal Marine. Those entities have to act through their representatives. And so that is the import of the language that Cape Coastal Marine has to act through James G. Spalt, its manager. And that's why that is in there. And I will point out, Your Honor, that Jamie Spalt, James E. Spalt, knew about that import, and he knew about that.
How did he know that?
Because Judge Hogan, who found the contempt, Judge Hogan's decision.
The Judge Hogan's decision does not mention the June 14th, 2000, at least the one I read,
Right.
doesn't mention the 2014 order, does not mention Cape Coastal Marine. Now, maybe there was a second order, but the one I read, which one, what's the date of the one you're relying on?
This is the, it's at volume 5, page 237, when she explains. There's only one Judge Hogan order.
It's dated October 28th, 2015.
Yes.
Where in that order does she mention the amended injunction?
She doesn't amend, my point is, she doesn't mention the amended injunction. She mentions and she analyzes the injunction. Now, the only difference.
But the critical language is the language about Cape Coastal Marine, right? Almost all this money that we're talking about, not almost all, much of the money we're talking about, the vast bulk of it is money transferred out of Cape Coastal Marine.
Right.
Okay,
That's
and
right.
she's not dealing with any language having to do with Cape Coastal Marine.
No, she's dealing with the language that deals with New Ranger LLC. The only difference between that original injunction and the modified injunction is that Cape Coastal Marine is added on. So if she found that New Ranger LLC, which she did, that moving money of New Ranger LLC is a violation of the injunction, then it has to be true that moving money of Cape Coastal Marine is a violation.
I understand that argument. Where does she address New Ranger Marine in this October 2015 order?
It's on page 20 of the order, page 237 volume 5 of the appendix, but it's page 20 of the order. And she specifically states, the temporary restraining order and the preliminary injunction thus clearly and unequivocally enjoin James Spalt, Kristen Spalt, and Jackbox LLC from spending or moving money held in their bank accounts and the bank accounts of JP Realty Trust, KG Family Trust, and New Ranger LLC. The only difference between this order and the expanded order in June was we found out that they stopped moving money out of New Ranger LLC and they started putting all the money into this new entity, Cape Coastal Marine. Otherwise, the two order, that the original injunction and the expanded modified injunction, the original is at volume 1, page 36, and the expanded is at volume 4, page 5. The only difference is the expanded injunction adds on Cape Coastal Marine LLC. So the analysis that went through, that Judge Hogan went through, is applicable directly to the new added on entity, which is Cape Coastal Marine.
What was the business of New Ranger?
New Ranger LLC was an entity that they operated, they bought certain boats down in Louisiana, and they ran businesses back and forth.
So it was an operating business that had income and had costs and expenses?
Yes, it had,
was an argument made to Judge Hogan, hey, you can't do this because you're going to shut down my business of New Ranger, and it needs to have carve out so that it can operate? Was that argument made to Judge Hogan?
That argument was made to Judge Hogan. It was made to Judge Frisson back in, and now this is important, that back in January, Jamie Spalt was served with the complaint and the injunction enjoining New Ranger. Between January and June, Jamie participated in trying to negotiate a carve out so that New Ranger could spend its money. Judge Frisson in June denied that request. And at the same time, she expanded. She said, I'm not going to allow the carve outs, and also I'm going to allow the injunction to be expanded to now cover this new entity, Cape Coastal Marine.
So if we go into the record, we're going to find that history that you just described. We're going to find arguments that say, hey, you shouldn't construe this to apply to asset transfers out of New Ranger because you're going to, if you do that, you're going to shut the business down. And then we're going to find the judge's orders. Okay, thank you.
Judge Frisson said no. And then, how did Jamie know about this? Well, Jamie knew about this Judge Hogan's order because he assisted with the carve outs he was involved in New Ranger and the carve outs. And he cited this order in his pro se letter to the court, which was, that was November 16th, 2015, when he filed a pro se pleading with the court, demonstrating not only the full knowledge of the injunction, but also all the negative ramifications that injunction was having against his family, the carve outs, that letter that in his own language, he wrote to the court explaining that the carve outs were not accepted, the freezing of all of their assets and their monies and the bank accounts, and the binding nature of that. So this idea that Jamie did not know or have actual knowledge of the injunction, Judge Giles found 5 occasions where he participated and received notice of the injunction and its effect. Now, those 5 occasions were times when, if James E. Spalt had any question whatsoever as to the effect of what was enjoined and what wasn't enjoined, he had the obligation to come into court and ask for clarification. He never did so. He now complains that either he didn't know about the order until 2018, it's demonstrably false based upon the record, or he knew about the order, but he thought it was ambiguous and he couldn't understand it.
Okay, thank you. Thank you both. We'll take this under